Good afternoon. Welcome to the Joint Government Operations Committee. Madam Secretary, if you would, please take the roll.
Senator Bowling is present. Senator Crow is present. Senator Jackson is present. Senator Kyle. Senator Lowe. Senator Oliver is present. Senator Rose. Senator Taylor is present. Chairman Roberts
Here.
is present. Mr. Chairman, you have 6 members present. Rep. Bolso is present. Rep. Chisholm. Rep. Clemens is present. Rep. Crawford is present. Rep. Eldridge is present. Rep. Faison. Rep. Hakeem. Rep. Hemmer. Rep. Johnson is present. Rep. Jones is present. Rep. Kiesling is present. Rep. Kumar is present. Rep. Lafferty is present. Rep. Lamberth is present. Rep. Littleton is present. Rep. Martin. Rep. McCallum. Rep. Reedy is present. Rep. Rutter is present. Mr. Chairman, you have 12 members present.
Thank you. I'd like to take a moment of personal privilege before we get started. And then if any other members have any announcements that they may wish to make, we'll recognize you then. There are 2 people that I want to recognize this afternoon. The first is Jaya, who is our research analyst. And I failed to do this. I wasn't here at a previous meeting, but she has now been with the committee for a year, and she has just done an absolutely outstanding job. And if you all just give her some recognition for a job well done. You're welcome. Now, this next one is a little bit more difficult because some of you may already know this, but this is going to be Janet Batchelor's last day as a legislative assistant for the Government Operations Committee. And Janet has been my legislative assistant for 10 years. And I don't think that this is any secret, but I think many people know that I have known her entire life. And my first words that I recall her ever saying was calling me that boy trying to get me off our grandfather's lap. So I have known her her entire life. She has been my legislative assistant for 10 years. And then prior to that, she was, we owned a business. She was our office manager. So we have worked together for many, many years, and she gets multiple gold stars for that. But she has an opportunity for what I would call promotion. She's going to move to Leader Johnson's office and be his legislative assistant. And we are going to miss her a great deal. But committee, if you would, show your appreciation for Janet. I've already, many of you have been the beneficiary of the cookies that she brings to the office. I've already laughed about, I wonder how many people I'm not going to see anymore because there'll be no cookies in the office. But she actually told me that Jack doesn't get cookies. So I am going to remain a little bit special there in that she's not going to bake cookies for him. So let me recognize any other members with special announcements, special orders, and then we're going to talk about the calendar just real quick. Anybody else? So, Representative Jones, you're recognized.
Thank you. Thank you. I just want to recognize that this month is Native American Heritage Month, where we honor the culture, the language, the resilience, and ongoing resistance of our indigenous communities here. Here in Tennessee, we occupy the ancestral hunting and traditional lands of the Cherokee, Shawnee, Choctaw, Yuchi, Chickasaw, and Creek people. And today, these people have nation boundaries in Oklahoma, North Carolina, and Mississippi after the Indian Removal Act of 1830 led to the forced removal of Southern tribes west of the Mississippi River. And so I just want to recognize our indigenous communities, our commitment to continue to fight for their rights and sovereignty, and also recognize, particularly in this space, that unless you're indigenous, you came from somewhere. And so many people your ancestors came undocumented from Europe as immigrants and settlers here. And so I want to recognize that this is the original homeland of the Cherokee, Choctaw, Chickasaw, Yuchi, Shawnee, and Creek people. Thank you so much.
Anybody else with personal orders? Senator Crow, you're recognized.
No, I would just thank the representative for that. When my father died, I found a picture of my great granddad, who was one half Cherokee, and didn't know that. Started looking into it and found out that actually it went back to the Yuchi tribe that he mentioned. Most people don't understand that the Yuchi were here in the 1400s when, in 1500s, I guess, when the Spanish conquistadors came to our area, and many of those Spanish conquistadors married the Yuchi women and took them back with them, and then obviously the disease they brought pretty much did the tribe in, and just the word Tenatsi is a Yuchi word, one of their villages that when the Cherokee took over the Yuchi village, after most of them were gone, became obviously Tennessee. So you're right. We should be very proud of that our ancestors, and we did pass legislation right before you came, I think, that references Tennessee's first people in the Blue Book. And so we made sure that those that you mentioned are in there. So thank you for doing that.
Thank you, Chairman Crow. Any other personal orders or announcements? Seeing none, let's talk about the agenda today. We, without objection, we're going to move item 9 to follow item 1. This is the permanent rule that the Department of Agriculture is presenting. The first thing on our agenda is their emergency rule, and since they're related to the same topic, we're just going to hear one after the other without objection. Okay, seeing none. The next item change without objection, we will move item 5 for the TWRA to follow the Department of Agriculture. So see no objection, that will be the order today. Anything else before we get started? Department of Agriculture, if you'll come forward, we have item number 1 on the agenda, an emergency rule that you'll be presenting. This rule was filed on June 28, 2024. It became effective on that date. The rule was rolled by motion of the Joint Rule Review Committee at its October 15, 2024 meeting until the Rule Review meeting scheduled for today. Leader Lamberth, you're recognized.
Mr. Chairman, after the testimony will be fine.
Okay, thank you, sir. So if you would please, I know we got a new microphone system, and if you would, you'll have to turn off your microphone after you get done speaking to make sure that somebody else can speak. But if you would, please be sure to state your name for the record, and if you would give us an explanation of the emergency rule. Thank you.
Thank you. Can you all hear me? Excellent. My name is Annie Belgetti. I am one of the attorneys at the Tennessee Department of Agriculture. I am the primary support attorney for the hemp program, and I am here today to talk about the department's emergency rules and the permanent rules. So our emergency rules were promulgated because the statute that was passed in July of 2023 required retailers, manufacturers, suppliers, distributors of products containing hemp-derived cannabinoids to have a license. And we needed a licensing program in place in order to do that. We had over 19,000 individual comments on our permanent rules, our rulemaking hearing rules. So in order to make sure that we could get those businesses compliant with the statute, we promulgated emergency rules in order to establish that licensing program. And in those emergency rules, we only included the information that was necessary to obtain a license, because under this statute, applicants for a license needed to submit information prescribed by rules by the department. So that's what those emergency rules did or do. They set up that licensing program so that retailers, distributors, manufacturers, et cetera, of hemp-derived cannabinoid products can get a license. They're in place now. They expire on December 25th. And then our permanent rules are scheduled to be effective on December 26th.
Thank you. Chairman Lamberth, Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. At this time, I know there are still some questions about the rules, and this is a little unorthodox, but I would make a neutral recommendation.
Okay. Would you like to give members a chance to go ahead and ask questions, and we'll come back to your motion? Will that be okay?
Yes, sir, Mr. Chairman. I apologize.
Okay.
I had asked to be recognized after the testimony, and I was just going forward.
What we'll do is we'll take questions for the Department of Agriculture, and then we'll also have our public comment, and then we'll come back to your motion. Okay. All right. Any questions for our guests today? Members, any questions? Okay, we do have several people from the public who signed up for both this rule and the permanent rule. And what we're going to do is go ahead and have the public testimony now. The rules are so similar that what I'd like to request, if we can, is that you just pick which rule you want to give your testimony on. Also, we'd like to ask if you're representing the same organization. We'd like just to have one representative give the public testimony. We also, characteristically, when we have a lot of people signed up, we limit that to 3 minutes. And I don't think that will probably be problematic with this, but let's go ahead and get started on the public testimony. And the first that I have is Michael Solomon. And here's what I'm going to ask you to do. I'm going to ask you to either give your testimony on this one or give your testimony on the next one, but not both, if that's okay. So, Michael, if you wish to come forward, you're the first person who signed up, or we can have you wait for the next rule. Your choice. You wait for the next rule. Okay, wait for the permanent rule. Chris Summerall, do you want to go now or you want to wait for the next rule? Okay, you'll go now. Okay, and you also, I see Kathy Lennon is also with the same organization. Are you good with presenting for both of you? Okay, thank you. Just state your name for the record, who you're with, and we'll give you 3 minutes to give your testimony. Thank you. You need to have your microphone on, and if you'll push the button, there you go. You're good.
Sorry, guys. I'm
You're-
a fish
you're
out
good.
of water. I
You are good.
shovel dirt every day for a living. Okay. USDA farm number 2170, USDA license number 470537. We have 16 permits that the state's given us at this point to cultivate cannabis, process cannabis, and sell cannabis retail. First of all, I want to congratulate you guys and Representative Lamberth. This is groundbreaking legislation. This has never been done before in our state or the U.S. or the world. We are bridging gaps in the cannabis community, and I applaud you for your efforts. Since this is the first of its kind, it definitely, we're not all the way there yet, but I don't think any bill of the first of its kind, is right there where it's supposed to be. Our problem with this is in a manner similarly reliable to post-decarboxylation. There's a lot of interpretation with this. It's very unclear on the science of this, and I think we can fix this. I think this is a safety situation. In our opinion, and the way we look at it, this is going to take the flower, the plant that we are permitted to grow by the state of Tennessee, off the table for retail, if we're interpreting it the way the Ag Department is interpreting it. So it's again, there's a lot of science involved in this. This is very unclear to the farmer. This is very unclear to the retailer. I think that it would probably be best if we just could, scratch this out and look at this in January. And that otherwise, this bill's great. It checks all the boxes. There might be some safety issues with public consumption. From the parking garage to here, I walk past 2 groups of people smoking cannabis. To me, that's a problem. If I'm in the park with my family, I don't want people that look like me posting up next to me smoking cannabis. I'm going to move down the way. Okay. And I think that is something we potentially should address with this bill moving forward, but we can't take away the flower from the retail sales. Okay. What do people do with the flower? They smoke it. Okay. We can't stop them from doing that. If we take this off the counter and don't regulate it and tax it, they're going to go to the black market or take their business across state lines. North Carolina just pretty much cut and pasted this bill. They did. And they have flower provisions in there. This is great. I mean, this bill is awesome, guys. We love it. We love it. We don't want to chunk it, but we just need to work forward so that the farmer has a chance, so that the retail operator has a chance, and that the state has a chance, and that we don't send our patrons to the black market. That's where cannabis is the most dangerous.
Thank you. Chris, can I ask you where your farm is located?
Soddy Daisy, Tennessee,
Soddy
right outside
Daisy,
of
Tennessee.
Chattanooga. We
Okay.
have 20 employees right now, and we've been in it since year one, day one, 2015. We've met compliance. The state Ag Department's been in our building numerous times, said you checked all the boxes. And again, we can talk about the science for days and weeks. And if y'all want to come to our farm and our facility, I'd happy to explain it. There's not enough time in the day to start right now.
Thank you. Any questions for our guest? Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And thank you, sir, for testifying. I've worked with hundreds of retailers across the state over the last couple of years to try to get a bill that does have regulations in place and that we're not selling to children, that we're not selling products that people don't know what it is. And I want to be clear. I mean, do you have any objection to a licensure plan so that you have professional folks like yourselves that are distinguished from a 7-Eleven selling products of this nature?
I'm not sure the question. So you want just us sell, like, as far as 7-Elevens can't get a permit to sell?
No, sir. What I mean is, what we tried to set up here is that a professional set of licensed retailers that are selling known products where folks know exactly what they're getting, instead of just, when I walk into a 7-Eleven or a gas station, they sell anything and everything,
Yeah.
and a lot of it's just completely unregulated.
Absolutely.
Are you fine with the regulatory scheme?
I think it all needs to be regulated heavily. Absolutely. But we can't take the flower off the table, the actual plant. That sends everybody back. So right now, according to our market research, the hemp sector is getting 40% of the total cannabis sales in the state of Tennessee. Okay, the other 60% is either going to the black market or across state lines. Okay, so if you take the flower from the hemp market off the table, that our 40% is either going to go to the black market or across state lines. And I don't want the black market to succeed. Like, I really don't. Like, that is feeds other industries that are bad for our community. And we, to stop that, we have to give them a better product at a better price, and let's tax the heck out of it. I don't think we're paying 16% right now, 9.7 plus the 6% sales tax. Let's put another 4% on there. Other states are doing 23, 25%. There's more meat on the bone there, guys. As a farmer, we're happy with more taxation. We're fine with it.
Well, but as a farmer, I mean, you were, I'm sure, familiar with over the last several years, we limited it at 0.03% on how hot your crop could be.
Yeah.
And that's exactly what this bill and regulations have done. So are you sharing that you want to sell flower THCA above the 0.03%?
So now we're getting into the science of it all.
I don't see a way to avoid it.
Right. Okay, so if we're talking about decarboxylation, this is a chemical process that is done with temperature and time. Okay. Now, when we're talking about smoking the plant, this is a different chemical process called combustion. It's a much faster temperature, much higher temperature at a much faster rate. Experts cannot tell me that this THCA turns into Delta-9, which is the psychoactive narcotic in cannabis. They can't track that down because it's combusting. It's happening too fast. If I blow that smoke into a balloon and say, hey, test this, they're going to say, I don't know what that tests at. If I take this ash and say, hey, test this, they're going to say, I don't know what that tests at. Experts believe it turns into CBN, which is an intoxicating but non-psychoactive narcotic. Okay, long hair, deadhead, guys. I love the Grateful Dead. Anybody that uses cannabis will tell you that eating cannabis and smoking cannabis are two completely different things. Okay, I don't eat it at all. I don't like it because that's the Delta-9. That's the psychoactive narcotic. The walls can melt if you take on too much of that stuff. Okay, but smoking it's a different property altogether. That's combustion, not decarboxylation. So that's where the law is very confusing, because we're talking about decarboxylation to somebody that's a scientist. They're going to say, well, they're talking about cooking with it. Like, no, they're talking about using this to take the flour off of the table. Well, that's combusting it. That's a different chemical process. This is science, So again, like, THCA flour does not turn to a psychoactive narcotic until you cook with it through decarboxylation, which is decarboxylation's prime temperature is 200 to 250 degrees, but starts at 98 degrees. So just leaving that flour in the window can turn it to Delta-9. But if I'm striking a lighter to it, that's combusting it into a CBN and not a Delta-9.
So I want to understand what you're kind of leading to there. So as long as it's a 0.03 and it doesn't totally prohibit you from selling products below 0.03, you're okay with regulation. You've just got an issue with the flower aspect. Is that fair enough?
Yeah, we got to keep the flour on the table.
Okay. All right. Well,
Yeah.
thank you. I appreciate it. And look, I've worked with the community on this for years.
It's so confusing.
And
It really is.
I've learned a lot over this and continue to learn, but I didn't
too.
think it was confusing. It is very scientific, but at the same time, I think that's what the department has tried to do, is to comply with the statute where it says the 0.03. But I appreciate you coming today, and thanks for going back and forth a little bit. And I hope to continue to work with you guys on this. I anticipate there'll probably be legislation on this in the coming year. So,
Awesome.
but I do want the rules in place so that you can be licensed, so that other people can be licensed, so that we do have a professional retail organization out there that's not just anybody and everybody selling junk. So
100%, absolutely. Push for this bill 100%. We needed it. It was desperate. Senator Bowling's bill 5 years ago, I think we'd said that we would be here if that didn't go across the table, and here we are. But again, Tennessee, we're crossing new grounds here, guys. I mean, this is the first of its kind, and need to be proud of that. This is awesome. And North Carolina is getting ready to pass a very similar bill that allows flour, and we can do the same.
Chris, we have a couple other members that would like to ask questions. Representative Clemens, you're recognized.
Thank you, Mr. Chairman, and thank you for being here. Appreciate it. You keep using the term taking the flour off the table, and I think you may have explained what that means through the scientific, but is there a layman's, what about the policy takes the flour off the table, as you keep referring to that
Okay,
phrase?
so as the law states, so in a manner similar, reliable to post decarboxylation, and then there's a math formula behind it. So you take this number, you multiply it by this number, and then you add it to this number, and then you get a number that is similarly reliable to 0.3. And if we're under 0.3, then it's okay. And if we're over 0.3, it's not okay. That's very confusing. I didn't do very well in math in high school, guys. There's no college degree here. Okay, shovel dirt for a living, family farm, generational. Okay, I can't understand this law, you know, and I'm not saying that like it's not something that can work, but we just have to make it so that guys like me can understand it, you know, and from what they're telling me and what other people in the are telling me in law enforcement, that this says that the flour that I'm permitted to grow, we cannot sell retail. And that's a problem. Like no business in the hemp sector is going to survive without being able to sell the actual plant that we're permitted to grow. Doesn't matter if it's CBD flower, THCA flower. There's 240 different cannabinoids in the plant. We're only talking about a few here. So this is a game of genetics here. And the CBD flower will test over that 0.3 because it goes through decarboxylation just the same as the THCA flower does. And that's why the Ag Department gave us 30 days in the beginning. In the very beginning, it just went off of Delta 9, the federal farm bill. And everybody failed the test. And so the Ag Department said, well, hold on a second. We're going to lose this whole pilot program because nobody can pass this test. So let's give them 30 days before harvest to take the test. And so on an agricultural standpoint, we have 30 days before our plants are harvested to take that test. So they come in, they test the plant, and every day after that, cannabinoids are forming. You know, it starts off at 0.2, and then by the time it's, 30 days from there, it's all the way up to 20. You know, so I mean, that plant that's harvested is way different than that plant that is being tested. And that plant that makes it to retail is way different than that plant that was harvested. It's changing through its whole lifespan. Does that make any sense?
Representative Clemens.
Yeah, thank you, Mr. Chairman. And so what I'm hearing you say is we take the flour off the table as you've described it, in a way that I can understand it. We're talking about farmers losing income. We're talking about retailers shutting down. We're talking about people losing jobs while the cost of living is increasing.
It's 92% of our sales in
Right.
our retail. We have 2 retail locations that we have 4 products that we make all of ourselves from the cannabis that we grow, hemp that we grow on our farm. And that is, 92% of it is the actual flour that is produced from the plant.
Yeah.
So, and if a lot of people, retailers that we've talked to, the Tennessee Department of Revenue has done the study, and as you pay your 6% hemp tax, it gives you options of where this money came from. And THCA is on there, and everybody we've talked to is saying like, oh, well, we don't even say that it came from THCA because we don't want to get in trouble, and so we just put other. And so a lot more of that money that's coming in. I mean, what was it, $15 million? I don't know the actual. I'm sure somebody here has that math, but it was a lot of money that the Department of Revenue's gotten in the last 6 to 8 months. I mean, millions.
Yeah.
And it would all go away if the industry goes away.
Yeah. Okay. Well, thank you very much. It seems like it has a significant economic impact on the bad side. So thank you.
Thanks, guys.
Thank you. I have Senator Bowling, then Dr. Kumar, then Representative Johnson. Senator Bowling, you're recognized.
Don't like these mics. Thank you, Mr. Chairman. And thank you for being here, Chris. For a point of clarification, a lot of people, you say cannabis and people think marijuana and whatever. We're talking cannabis and come down and fork off. There's hemp and there's marijuana.
Mm-hmm.
Marijuana is a controlled substance.
Mm-hmm.
Hemp is not a controlled substance.
Right.
And what you do with hemp is going to still equal hemp.
Yes.
And so to put a regulatory oversight on it that says you can no longer sell this hemp product is controlling a a product that is not a controlled product. Does that make sense?
It does, yes, ma'am.
And so I think I'm going to have a motion to bifurcate that out of this because that is a confusing thing. And I know there will be more legislation coming up next year. And rather than disrupt what's in place, I will go ahead and state that I'm going to do that because you answered the question. We're talking cannabis here, hemp here, marijuana here. Marijuana is regulated, and I tried to get medical marijuana
Absolutely.
legalized in the state of Tennessee and never could get a motion or a second.
We tried.
But I
we tried.
was invited to the state of Alabama where they passed my medical cannabis bill, and I was there when their governor signed it into law, and it was a bittersweet moment. But I'm grateful that they are able to get that medical benefit without a lot of the psychotropic aspects, even with medical cannabis.
And hemp has a lot of the same properties.
Right.
Not
right.
all of them, but a lot.
Right. And so there are things that can be done medically with hemp that are preferable to a lot of the things we have later on our agenda today about this many controlled substances that are chemical products that pharmacies sell every day that are far more dangerous than anything we're talking about right now.
Agreed.
But thank you very much.
Yes, ma'am.
Thank you, Dr. Kumar.
Thank you, Mr. Chairman. Thank you, sir. You're very straightforward and candid about things, and we appreciate it. Are you growing cannabis or are you growing hemp?
Hemp,
Hemp.
as,
Okay.
as,
in the
as
beginning,
tested by the Tennessee Department of Agriculture.
in the beginning, you said cannabis, and I was a little
Well,
confused.
I like to use the Christmas tree analogy. There's no such tree as a Christmas tree. It's a Douglas fir that we put ornaments on. So all hemp and marijuana is all cannabis. Okay. And if you look up the definition of hemp, it's cannabis L sativa. And if you look up the definition of marijuana, it's cannabis L something else. Like, I'm not a scientist.
But you're growing hemp.
Yes, sir. Permitted by the state of Tennessee.
And this matter that you mentioned that it is tested 1 month, 30 days before harvesting, and it comes at 0.2. And then, of course, it keeps on growing. And by the time it leaves your farm, it is probably higher than 0.3.
Yes, sir.
Okay. And yet higher than 0.3 is not supposed to be sold.
Well, I think it used to be able to be sold. It's been changed recently. It's been changed every year since we've started this in this program. Every year they've changed it. But yes, this has just all come about recently, these changes.
But the current
before we
law-
had no problem with it.
Yep.
Thank you. But the current law is that higher than 0.3 is not for sale.
It's an interpretation of the law based off of similar, reliable decarboxylation. Okay, there's not a definitive number. That's a potential number. So if you guys want to give me a definitive number, I'm cool with it. Say like, instead of like similarly reliable to add this number, multiply it by this number, come up with this number, and we're potentially at this number, just say, hey, it's 5. And that I can work with. I can understand 5, but I can't understand similar reliable to post decarboxylation, multiply, add, subtract, get it all here, and then you're a criminal. I don't get that. Give me a number.
All right.
That's all I ask.
Dr. Kumar.
Last question. Again, I admire that you're very open and forthright, and you made a remark that if you are in a park and there are people around smoking and you have your kids with you, you'll move away from it.
Yes, sir.
How do you justify personally that those people smoking may be product that you sold to them, and yet you would move your children away from it, which I think is admirable, the good thing to do. But do you see a little contradiction there?
I look at it the same as alcohol, sir. I mean, open container, public intoxication, this is probable cause. If I was a police officer and I pulled somebody over and it smelled like cannabis, hemp, or marijuana, that's probable cause to go in there and do what you need to do. Like that, you're intoxicated. It is not, so hemp is not psychoactive, but it can be intoxicating to some extent. It doesn't matter if it's CBD, CBDV, THCV. I mean, again, 240 different cannabinoids in the plant.
Thank you. Thank you, Mr. Chairman.
Thank you, Dr. Kumar. Representative Johnson, you're recognized, please.
Thank you, Mr. Chairman. Mine's really quick. So what I'm gathering from what you're saying is that your problem with the rule is the part about the flour, that if that part were not there, you would be okay with the rest of the rule. Is that correct?
The
The
rest
part
of the
that doesn't remove the flour.
Yeah, the part
Okay.
that we don't understand about a math formula and similarly reliable to,
Right.
I don't know what that means.
So that's the portion you have a problem with.
Yes.
Cool. Thanks.
Thank you. Thank you, Chris, for being here. The next up is Jeff Sullivan. Do you want to give testimony now? Okay. Thank you. Come forward. And we'll ask the same thing, that you just keep your comments to 3 minutes, and then we'll see if members have any questions. But Jeff, if you would, please state your name for the record and also who you're with. And probably not a bad idea to let us know where you're from.
Sure. Yeah. Jeff Sullivan. I'm with Snapdragon Hemp. We're a retail hemp company out of Chattanooga, Tennessee. I'm originally from Memphis. Lived in Chattanooga for 6 years. I live here in Nashville now. So glad to be here. So I have a unique perspective of sort of the industry. I was one of the founders of New Bloom Labs in Chattanooga at the end of 2018, the beginning of 2019. So I have an understanding of the testing business. Also have an understanding of the retail side of this business and what the impact of this rule would have on the retail end. Basically, with that, just like Chris was saying, in fact, Chris was probably one of our first customers in the hemp industry, and he and his farm and his family do a great have a great product. But basically, what we have here is this one particular rule that would eliminate the THCA flour, like Chris said, would basically get rid of most of the retail industry in the state of Tennessee. This is an economic thing we're talking about here. We're talking about economics. We're talking about jobs. We're not necessarily, let's get off this 0.3. I mean, yeah, a test can easily tell you if a product is above or below the 0.3 total THC. Like Chris was saying, give these guys a simple number. Let's make the economics easy on them, right? The economy is what we have to talk about here. Chris will lose his farm. Chris will lose his retail industry, along with many, many other companies in Tennessee, if this particular rule stays in place. It eliminates that much of their total business, their bottom line. It will eliminate a huge portion of it. One important thing is this particular rule, the one we're talking about is the THCA, the flour, eliminating the flour. We have to think about that in terms of, it's sort of, if we eliminate the flour, this particular rule then no longer becomes sort of relative to the retailers at all, right? So I guess here's what I'm saying. We eliminate that part of the rule. Now we have nothing really to go off and to go and tell the retailers, hey, we're trying to protect you. We have rules and regulations. Well, this was really a big part of it. So we're sort of eliminating kind of what we're trying to do to protect the retailers here. If we eliminate this particular part of the, or if we have this particular part of the rule there, we're basically eliminating what we're there to protect them to do, if that makes any sense at all. So in closing, I'm not a consumer of the product, but I see the value to the industry. And I also see the negative economic impact of a thumbs up to this particular rule. So if there are any questions, I'll be glad to answer.
Thank you. Members, do we have any questions for Jeff? Senator Taylor, you're recognized.
Thank you. Thank you, Mr. Chairman. I just had one question. If the THCA rule stays in place, what will be the overall market look? What will the overall market look like from a grower or retailer who is complying with the new regulations?
Yeah. So thank you. Great question, Senator. If we eliminate the THCA flour, according to this rule, you'll open up a black market in Tennessee. and that black market will be very aggressive, and you will not be able to put a lid on that black market. It will continue to grow. Your tax dollars will no longer be coming in. It will be going into the black market. That's exactly what will happen. And you can't put the lid back on that once you've opened it.
Thank you. Any other questions for Jeff? Thank you, Jeff,
Sure.
for being here today and for your testimony. Next up, we have Alex. Looks like Alex Valley. Is that right? Do you want to do now, or do you want to do for the next role? Okay. And then finally, another Alex with Tennessee Growers Coalition. And I'm sorry, not sure how to say your last name. Do you want to go now, or? Little. Okay. I'm sorry. I'm trying to turn that into something. I promise you, I know what little, how to pronounce it and how to say it, but that's not what it looked like to me. It looked like
small. There's not
well,
a trick to
it kind of looked like UTTLE. You kind of put your I and your L together there, and that was throwing me off a little bit. So
That's Kelly's handwriting. I blame
Kelly,
her.
okay, we'll blame Kelly. Okay.
My name is Alex Little. Thank you, everyone. I represent the Tennessee Growers Coalition as their counsel. Tennessee Growers Coalition is the largest coalition and trade organization that represents hemp growers, manufacturers, and retailers across the state of Tennessee. Our response to these rules is very simple, very direct. If they are allowed to be implemented as currently written, you're going to lose about 60% of your industry, which is $150 million of economic activity. You're going to lose tens of thousands of jobs, mostly at the retail space. And the folks who are in the retail space are going to move out of state. They're going to move to North Carolina. They're going to move to Kentucky. They're going to move to Alabama. And they're still going to be able to send product into Tennessee because the products that they're talking about that this state administrative action would prohibit are all federally legal under the Farm Bill. This state has done yeoman's work creating a legislative regime which is fantastic and is a model and is the sort of thing that the Trump administration is looking at for how to regulate hemp in a nationwide way. I think the new administration is focused on opening up markets, not foreclosing them. And one of the things we may see is federal regulation. And they're going to look to Tennessee to that. But the one thing that they're not going to adopt is the one problem with this bill, which is a specific line that says THCA should not be permitted at a certain percentage. It is permitted at that percentage nationally. And the reason I think we bring this to you and the reason it's appropriate for GovOps is the legislation is strong. Legislation is solid. And much of the rules, I think you've heard this from Farm to Med earlier, we're not saying we don't need the rules. We need licensing, we need labeling provisions, we need to keep us out of the hands of kids. But there's one provision of this rule that the Department of Agriculture has enacted, which will eviscerate all the good that's been done in every other piece of it. And so I think the primary message today from my coalition, which again, I mean, we represent hundreds of millions of dollars of economic activity in the state. There's been more than $1 million a year tax revenue coming in since July of last year. Half of that goes to the general fund and revenue. Half of that goes to the Department of Agriculture. We know from that revenue, and that's if everybody is paying. And right now, I'll be frank, I don't think everybody's paying the tax because they haven't learned about it yet. I mean, we're having to educate people. But we know from that hard data how big this industry is. And the things that legislation is doing right in terms of the way to make sure that we're keeping out of kids' hands. And I represent dozens of these retailers. They're all changing the way they're doing work. They're keeping it behind glass cabinets. We're carding. The industry is looking much more like a robust alcohol industry or robust tobacco industry. And I think that's what we as a state should promote and encourage. If you give a good recommendation, don't send a message to agriculture that the best way to deal with this, if there's a problem, is to take it into session and fix it in session, because then you have the tools as legislators that the administrative state just doesn't have. We know a lot from some of the working with the Agriculture Department that they, not of their own fault, were not tasked properly with the manpower to look at these issues. They were overwhelmed by comments, and ultimately you're asking 3 or 4 people in the general counsel's office, maybe the brightest and smartest in the state, but they can't approach this problem with the same sort of legislative decision-making and balancing of interests as you all can. And so our request today is to find a way to send a recommendation as to that small specific provision. It's 8010-2.05 2A1 subset 6 2.
I want you to repeat that again, please.
So there are a whole class of rules here.
No, just that reference that you gave.
I'm going to reference this.
All right,
This
good.
is just to give you,
Got it.
there are different chapters of rules here. 801002.05 is what regulates distributors, the manufacturers, because ultimately that is the set of rules that determines what products can and cannot be sold. Underneath there, there's a testing provision, 2A, that sets different tolerances. It says these tolerances will be allowed to be sold, these tolerances will not. Under 1, 6, and then Roman numeral 2, so it's the number 1, subet 6, Roman numeral 2, it limits HDC products to a post-decarb THC value of less than or equal to 0.3%. If that provision were struck, the issue with flour that you heard described to you would go away, because the flour would have to be a compliant flour, 0.3% Delta 9, which is what the statute requires. But this would change that standard across the board and essentially rewrite the entire statute in one rule of legislation, one rule of administrative action. I would hope, and I think my constituents, and I mean that by the trade groups and all the people they represent, would hope that that's not how we're going to legislate their industry, that we're going to do it with the full panoply of, hearings and considerations and time that you all take into consideration most of the time, particularly with an industry this large.
Thank you, Alex. I want to go back to your reference again because we've got this particular rule, emergency rule has, 30 some pages in it. And I'm not sure I got the reference because
And I apologize. The reference I'm giving you is to the permanent rule.
Okay.
And one of the reasons I'm giving it to
Got
the
it, okay.
permanent rule is because the emergency rule it does have the licensing regime, which Ms. Balgatti talked about, but it also has sort of draft kind of, here's what we think the real rules are going to look like, but none of those were effective yet. So this, the emergency rule talks about this same provision, but it doesn't become effective until the permanent rule makes it effective on December 26th. And so the one that I gave you is the permanent rule, which is the one that no matter what happens with the emergency rule is the one that will ultimately carry the day as to whether or not these products will be vastly circumscribed.
Alex, I want to call just kind of a quick timeout for the benefit of the members. Under the APA, we sort of have a process if somebody, and I do know there's been some discussion about bifurcating the rule. I'm going to turn our attention to Doug Garrett, who's our legal counsel, to explain this, because if members are contemplating this, there's a way you do it and a way you do not do it. And I'm going to recognize Doug to explain that. Doug Garrett with legal.
Thank you, Mr. Chairman. Doug Garrett with the Office of Legal Services. The guidance that the committee has been given through the years is that if you are going to bifurcate a rule, there are sort of two things that really need to be looked at. The first is that you can only bifurcate, and this is the guidance we've been given, you can bifurcate down to what we call the point number. And below that, any subdivisions that would be bifurcated, they all have to be bifurcated, not just certain ones. Secondly, this rule, if you do bifurcate, really needs to still be able to stand on its own. In other words, you can't gut the rule and leave a portion thereof to continue on. So that's kind of the parameters that we're dealing with.
Thank you. So let me make that very practical. So if you bifurcate a section, if you do it at the 0.0 level, you're removing everything under that 0.0 level. And for example, if you took out, say the one that said definitions, you'd be taking out the definitions for the entire rule. So just I add that because there's a way to do it and a way not to do it. And you can just everybody, we're trying to give full information here so legislators can make good decisions. Let me turn our attention to see if we have any specific questions for Alex. Chairman Crow, you're recognized.
Yeah, so the duty of this committee, and I guess the beauty of this committee as compared to how things work in Washington, D.C., is that our job is to make sure that the rules that come before us match the legislation we pass, the intent of the legislation that we pass. So the department is saying that that's what this does, right? The department's saying this rule, as written totally, matches what we passed legislatively, which would lead you to believe that if we want to change it, we got to go back and change the legislation. So the department's saying that it matches. Are you and your colleagues are saying that it does not match the legislation that Leader Lambert and we voted for?
That's correct. And I can give you sort of two specific provisions that relate to that. There is a reference in section 207 of the hemp statute, the hemp-derived cannabinoid statute, that talks about post-decarboxylation testing. It says when the department does testing, it has to use a certain testing method. You heard some reference to that testing method earlier. There's no other reference to that testing method anywhere else in the statute. And most importantly, there's no reference to that testing method in the provision of the statute at the very top, which says which products are legal in the state of Tennessee. That sort of list of what products and what potency is 4 sections removed and entirely disconnected from section 207. In fact, in section 207 that talks about testing, it sets 2 different testing provisions. And I think this makes sense as a legislative matter. If you are a manufacturer, you have to get your product tested by a third-party lab. You've got to go out, you got to pay for it. You got to show that it meets all the standards. And then separately, the state itself can go in and do sort of checkup testing, and it can sort of watch what's happening in the industry. The section that the department is relying upon to add this whole new rule, which would eviscerate 60% of the products, is in one sentence and one clause of the section that talks about the sorts of backup testing, evaluative testing that the department should do. So we do believe strongly that the state legislature made a very clear statement as to here's what products are legal in this state. And agriculture has really sort of, I think, taken the small piece and moved it and made it swallow the whole. So I hope that's responsive. And I will say to Chairman Roberts, I don't want to take up any more time, but to the question about bifurcating at the point level, if you bifurcated at the point level with respect to this rule, you would essentially take out the sampling and testing provision as it relates to manufacturers and distributors. That is a section that is predominantly discussed in the statute already. There are a good number of provisions in the statute as to what should and should not be allowed. And the legislature could very well in the next session establish what those standards are in a way that the industry would have input on, and I think could feel more consistent with what is present in other states. There was a reference to North Carolina. North Carolina doesn't have this prohibition on THCA above 0.3. So you will have hundreds of thousands of products that are legal across that border that can easily come here and be sold here, be possessed by people in Tennessee that our own manufacturers and retailers can't use. And so you could bifurcate it there and spend the time in session figuring out what sort of sampling testing we want to apply to those products.
Thank you. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. So, Mr. Little, what I hear you say is if we take out the 0.05 section, the sampling and testing provision from this, based on Mr. Garrett's explanation of the rule with regard to bifurcation, if we take out that 0.05 section, the rest of the rule can stand on its own merits and comply with the law still. Is that correct?
It can. Let me tell you, it would include things like labeling. You'd have to still label the products with where they're from, with what they contain. You'd still have all the retail requirements. This rule in particular is not a retail rule. It is a manufacturing rule. And so all the retail rules, all the labeling requirements, it can't be things that appeal to kids. All of that will stay.
Thank you.
Now do keep in mind, Representative Clemens, he's referring to the permanent rule, which is the next item that I don't know that we've established where this is in the emergency rule.
Your Honor, I think it has changed a little bit from the emergency rule.
That's very kind of you to call me Your
Well, I
Honor, but
apologize.
I'm
I do it
not,
every day.
I'm not judging you today, okay? So.
Well, we can get you a
yeah.
black robe and make
Yeah.
that work.
Yeah, I'm not sure where this is in the emergency rule. And so that's just a reference you might want to be aware of. I'm going to move to Senator Bowling. Did you wish to be recognized? Because I think I'd Leader Lambert who wished to be recognized.
Actually, no, I think that I will make my recommendation in the permanent rule.
Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And Mr. Little and I have known each other a long time. He's
Yeah.
a zealous advocate for his clients and a great attorney. But with all due respect, I mean, you didn't sponsor the bill. You didn't spend months working on the bill. You didn't spend blood, sweat, and tears to try to form this and work with hundreds of retailers to try to get there. It absolutely was the intent of this legislation to ban products over 0.3%. Flour, any other products, anything. We wanted products to be available out there that are hemp derived, that quite frankly is not like what I see on the billboards now, real weed, buy it now in Tennessee. where they are literally advertising products, where they are trying to dupe people into think that it's actual Delta 9 THC or marijuana or something else. And they're advertising it specifically for the purpose of trying to sell recreational marijuana. We wanted to cap it at 0.3%. We wanted folks to have testing done, which if you got this particular provision, then the testing that is going into this and the labeling that goes into this, we wanted to make sure that if someone is buying a product that is under that 0.3%, they know exactly what they're purchasing. When both the department and different law enforcement agencies throughout the state have tested some of these products over the last few years, just like the CBD conversation we've been in, some of the stuff that people were buying was extra virgin olive oil that was in a capsule that was being sold as CBD that people were bringing home and giving to their kids thinking that it might prevent seizures. And they were being duped into selling something that was not what it was advertised as. So a huge part of this was to have a regulatory scheme, a license scheme, just like the gentleman said beforehand, where you have a professional group of vendors in the market out there where people know exactly what they're getting. Now, if folks are not happy with the 0.3%, and I understand that you are not, that's something we can all deal with when the legislature begins in January 14th at noon, and folks can bring bills and we can debate where that should be. But specifically on the very first page of Public Chapter 423, it talks about 0.3%. It goes through and it references it all the way through, and it is interwoven with the testing part of it. So without that particular section, this entire thing falls apart because people then don't know what they're getting again. And I want Tennesseans, if they are going into a retail establishment here or a retail establishment, if they are purchasing from a manufacturer, to know exactly what they're getting. And I think anyways, that is what your entity wishes to have. So that's what we tried to develop. And Senator, thank you for bringing it up on what the intent was, because I worked pretty hard on this and worked with everybody to try to get to a point where we draw a line in the sand and say 0.3% or below, it's fine. You can sell those products, you test them, people know what they are, label them, don't sell to kids, make sure to card and everything else. But above that level, we're not going to sell that. And so that's what we're talking about here. I just don't want to gut something that we spend an enormous amount of time putting in place. Yeah. And I really don't want the industry to wind up in a place where you're back to folks, again, just going into a 7-Eleven and getting duped with whatever product they may see on. And I hate to pick on 7-Eleven. I actually like 7-Eleven. The, ices are pretty good. But you shouldn't be buying your medicine there, so.
Well, so Leader Lamberth, I will tell you, our intent is not to tell you what you did. But I will say, I think that I may have been confusing in the way I talked about it. No one in the industry wants you to change the 0.3 Delta 9 THC levels. That is a federally standard level that is set by the Farm Bill in 2018. That 0.3 is the law, and everybody wants it to be the law. But it's sort of like comparing touchdowns to first downs. Touchdowns give you 7 points. We know the rules. That's easy. Nobody said if you get 10 first downs, you automatically get a touchdown. These rules try to do that. They say, well, if you got this other stuff, THCA, well, we're just going to count it just like it's Delta 9. And that's a different way of doing math. And I think the first speaker from Farm to Med spoke about that. That way of doing math isn't in the statute. And so what's confusing, I think, for the industry is they saw a law that said 0.3 THC Delta 9. We can understand that. We can do that. This rule says, well, actually, if you've got some of these other compounds, specifically THCA, we're going to count it just like Delta 9, and we're going to do it this way. Which is, I think, fair for them to say, those aren't the rules we thought we were getting. And so I understand nobody wants to gut the rules. And I think what I'll tell you is that if you took out the 0.05 section, you don't lose sampling and testing because it's in your statute already. You don't lose COAs, you don't use labeling because it's in the statute already. Those things are required by the legislature, irregardless of that particular regulatory provision. So I think I understand nobody wants to go to the place that you're describing. But what the industry wants is some clarity about what was actually decided. And the fact that we've been able to sell things as an industry for a year that won't be able to be sold December 27th, I think tells you that there's been a change of the status quo. And I think that's what the industry doesn't want. Don't change the status quo, particularly through administrative rulemaking process as opposed to a legislative one.
And Chairman, the only thing I'll say in response, and again, well argued as always, I mean, that's how you make a living, man. You're very good at it. But We absolutely wanted to change the status quo. We wanted to have specific products on the market that Tennesseans knew what they were, and we were not comfortable with the status quo as a legislature where folks could buy anything and everything and many times have no idea what it was and no consistency in what they were buying. Sure. We had folks that were overdosing, going to the hospital and everything else because they may get an edible at one place that has 5 milligrams of something and edible somewhere else that's got 25 milligrams of something. You know what I'm saying?
Sure,
there was no consistency whatsoever, and that's just not a good market no matter what it is. If somebody out there buys a Sprite, they shouldn't get a beer. If they buy a beer, they shouldn't get a bottle of tequila.
Absolutely.
I mean, if you want to use, kind of liquid substances. So that is exactly what we've tried to do here. And I think that we have, and I think AG has followed the statute exactly as we asked them to. But that's just my opinion. Thank you.
I appreciate that.
Thank you. I'm going to interject here, which I'm always reluctant to do. I take great pride as a chairman in letting the committee go where it wants to go. But I just want to make a point. This is an emergency rule that's already in effect. It stays in effect until December 25th. And to my knowledge, there's not anything that we would do in a recommendation that would change that. A lot of our discussion really is around the permanent rule. So here's what I'd like to do. I'd like to, just from a procedural standpoint, I'd like to move this rule out. We've got, Leader Lambert said that he was going to make a motion for a neutral recommendation. It could be positive, it could be negative, it could be neutral. You could bifurcate, you could not bifurcate, but at the end of the day, it's already in effect. It will stay in effect until 12/25. Now, that's not necessarily true on the permanent rule, and we've sort of moved into a discussion of the permanent rule too. So without objection, what I'd like to do is I'd like to go back to Leader Lambert's motion and let him restate his motion. And if we have a second, let's just go ahead and take action on that. And then let's move on with our agenda, because in many respects, this discussion that we're having right now is somewhat academic. It's not academic with a permanent rule, but it is on this emergency rule. So without objection, I'd like to recognize Leader Lambert, and let's go ahead and have a restatement of the motion, and we'll see if we've got a second. We'll take a vote.
Thank you, Mr. Chairman. And the emergency rule only deals with really the licensing scheme. My motion on a neutral recommendation would have been on the permanent rules. I would make a positive recommendation on just the emergency rules. And again, they go away December 25th anyways.
Okay. So we have a positive motion for a positive recommendation. Chairman Crowe has seconded the motion. Do we have any discussion on the motion? Seeing none. Alex, I'm going to go ahead and say thank you. We may have you back for the permanent rule. But thank you for your testimony. Madam Secretary, if you would, take the vote in the Senate, and then we'll do a voice vote in the House.
Senator Bowling.
Aye.
Votes aye. Senator Crowe. Votes aye. Senator Jackson. Votes aye. Senator Kyle. Senator Lowe. Votes aye. Senator Oliver. Passes. Senator Rose. Senator Taylor. Votes aye. Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 6 ayes, 1 present, not voting.
Let's do a voice vote in the House. All those in favor, please say aye. Aye. Those opposed, please say no. The ayes have it. Noes would wish to be recorded, I guess. That'd be Representative Johnson. And okay. You can abstain. Yes. So if you'd like to abstain, Representative Jones abstains. All right. Down at the end, Janet. How do you wish to be recorded? Representative Clemens? Abstain. Okay. Thank you. All right. The emergency rule moves out with a positive recommendation. Now, I know we said we'd do the permanent rule right after this, but without objection, could we just have TWRA come forward real quick? And there's a reason I'm doing that. Could we just insert them without objection and go ahead and get them in and out? Is that okay? Do any members object to that? Okay, come on forward, Blair, for TWRA. We'll have you right back in just a moment, but let's get TWRA in and out. The reason why I'm doing this, and they are on kind of a time-sensitive schedule here. And members, Blair Beatty is our new liaison for TWRA, and we have all seen her before. And I know she's got to leave. She's got a flight to catch. And so I just want to get them in and out. But it's work. Yeah, it's work. It's not play. But
not a fun play.
Yeah. So Blair, if you would state your name and the new agency that you work for, and if you would give us an explanation of your role.
Yes, sir. Thank you so much, Chairman, and thank you to the committee for letting me jump ahead and to the people waiting patiently for their turn who have allowed me to jump ahead. Blair Beatty, Tennessee Wildlife Resources Agency, and with me I have Josh Campbell, who is our Chief of Biodiversity, as well as Daniel Cox, who is our Assistant General Counsel. Josh is also, I just think this is important for everyone to know, part of the 1998 UT Volunteers National Championship Team football. Go Josh. Chairman, Tennessee is one of the most biodiverse states, ranking 13th in the United States for non-game species diversity. The Tennessee Fish and Wildlife Commission, through the Tennessee Wildlife Resources Agency, is responsible for managing and conserving non-game wildlife species. So when we say non-game species, we're talking about the mussels that filter our water in the Duck River, and we're talking about the bats that eat insects, keeping our costs down for farmers. Part of that management includes maintaining the state's list of endangered, threatened, and in need of management species. Every 2 years, the agency reviews and offers recommendations to the list to the commission. These recommendations are not done in a vacuum. They incorporate data from experts across the state and Southeast. The rules before you today will update the list by removing 27 species and adding 28, increasing the grand total from 143 to 144. The rules also incorporate by reference the species listed under the federal endangered species list and correct the names for several different species. And with that explanation, Chairman, happy to take any questions.
Thank you, Blair. Members, do we have any questions for Blair? We have a motion for a positive recommendation from Representative Littleton. We have a second from Senator Bowling. Any questions on the motion? Do we have any public comment? Seeing none, Madam Secretary, if you would please take the vote in the Senate.
Senator Bowling.
Aye.
Votes aye. Senator Crow. Votes aye. Senator Jackson. Votes aye. Senator Kyle. Senator Lowe. Votes aye. Senator Oliver. Votes aye. Senator Rose. Senator Taylor. Votes aye. Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 7 ayes.
Thank you. We'll do a voice vote in the House. All those in favor of a positive recommendation, please say aye. Those opposed, please say no. The ayes have it. The rule moves out in a positive recommendation, and I hope you're able to catch your flight.
Thank you all so very
Okay,
much.
thank you. Can we have the Department of Agriculture come back up, please? Thank you for letting us do that. Okay, members, what we're about to hear is the permanent rule, which is item number 9 on your agenda. And there are some differences between the permanent rule and the emergency rules. So what I'd like to ask the department to do is just to highlight what those differences are. And you'll need to state your name for the record again, since this will be as a separate rule. And then we'll see if members have any questions. And then we'll go back to the people that wanted to defer their public comment. So you're recognized. Thank you.
Thank you. I'm Annie Belgetti. I'm one of the attorneys at the Tennessee Department of Agriculture. I'm here to talk about our permanent rules. The emergency rules established a licensing program. They had further provisions in the emergency rules to give industry notice of what may be coming in the permanent rules, but those provisions were never to go into effect. Our permanent rules do have provisions that relate to the substantive portions of the licensing program. So when the emergency rules expire on December 25th, our permanent rules will go into effect. They will carry over that licensing scheme that was set up with the emergency rules, only they will add all of the substantive provisions of what's required in order to maintain licensure, what will be expected of licensees. So that includes testing of products for things like residual solvents, residual pesticides, heavy metals, toxins, all of the things that relate to consumer safety that were mentioned in the statute, but not specifically prescribed, which the department then fleshed out with its rules to discuss what the specific limits on those things would be. It was also, our permanent rules also talk about the manner of sale of products. One of the things that we did is we expanded the definition of counter so that retailers would be able to sell product in other areas of the store, not just behind the counter. We thought it would benefit retailers so long as the products are locked, so that a customer has to request access to those products so that we can maintain prevention of youth access, which was so important in the statute. It does also require testing of products in terms of THC concentration, cannabinoid concentrations. That's something that was required in the statute. So the department under the statute is required to test all hemp-derived cannabinoid products for their concentrations, and the testing method that we are required to use in order to test those products is a testing method in a manner similarly reliable to post-decarboxylation, which I'm going to have our director, Dr. Travis, talk about. But the department doesn't change the testing of products It doesn't change the statute. We merely follow the scheme that's laid out in the statute. All products must have a THC content of 0.3% or less, and all hemp-derived cannabinoid products must be tested using a manner similarly reliable to post-decarboxylation. It's important to note that that is the exact same language that is used in our growers statute. Our hemp growers in Tennessee have been subject to that same testing standard, testing provisions, and testing limits since 2021. They're not, it's required under federal law in order for us to have a state-run hemp program, and that's what our growers have been subject to. They are not allowed to grow anything over that 0.3% THC. And so when that language is carried over into the hemp-derived cannabinoid statute, we are looking at the exact same treatment of retailers, manufacturers, and distributors with these products as we are our growers. And I'm going to let Dr. Travis talk about what the language "in a manner similarly reliable" means, and its effect on hemp-derived cannabinoid products.
Please make sure your microphone's on and state your name for the record, please. Thank you.
Thank you. Adam Travis, Tennessee Department of Agriculture. I'm the lab director. So the matter that Annie has referred over to me is about the portion of the statute that requires testing by liquid chromatography, tandem mass spectrometry in a manner similarly reliable to post-decarboxylation. And I fully understand that there's a lot of confusion around that language. It's very confusing. So we have done our best in rule to explain what exactly that means. So liquid chromatography, tandem mass spectrometry. That is one of many different ways to quantitate any number of substances inside of cannabis, inside of food, inside of pretty much any type of product. And we regularly use that type of testing in the laboratory. The part that's really at question is what that "in a manner similarly reliable to post-decarboxylation." I believe that's where everyone's questions are. So as Annie mentioned, both the grower statute and the hemp-derived cannabinoid statute contain that language. This language aligns with what's in federal rule for the Domestic Hemp Production Act. Essentially, it requires us to consider what we had previously referred to as total THC, but we've struck that after discussion with industry, because there was still confusion about what exactly that meant. So the definition that is included in the in the rule describes kind of a mathematical formula that was discussed earlier. And that mathematical formula takes into consideration the potential conversion of THCA into delta-9 THC. So THCA is the primary cannabinoid that is synthesized by the plant itself. That's a naturally occurring cannabinoid. But over time, that cannabinoid will decarboxylate, again, as was mentioned previously, as a result of temperature or just over time. It naturally decarboxylates into delta-9 THC. So in order to capture the total possible amount of delta-9 inside of a product that may be sitting on a grocery store shelf, it may be sitting in a field, it may be harvested and put up in a barn to dry for a while. Eventually, all of that THCA, if just left alone, will eventually convert over to delta-9 THC. So with the statute requiring us to test by a manner similarly reliable to post-decarboxylation, we are taking into consideration that conversion of THCA into delta-9 THC. And that chemical process that converts THCA over into delta-9 THC is called decarboxylation. So by using a post-decarboxylation method, we are following just what is in the statute. Again, there's been lots of questions about this. I'm happy to try to explain to the best of my ability what folks may have questions about with regard to that.
I'm going to, pardon me, Senator Taylor, I'm going to ask a question. So I want to make sure I understand what you just said. You're testing what it is or what it could be?
So we are testing THCA in the amount that is present inside of that plant or whatever material it may be. Similarly, we're also testing the exact amount of delta-9 THC inside the plant. So we're testing them both in a manner similarly reliable to post-decarboxylation. So the mathematical formula is what makes it in a manner similarly reliable to post-decarboxylation, because the liquid chromatography tandem mass spectrometry part, that part prevents the decarboxylation from happening during the testing process, which is why we have to have in a manner similarly reliable to post-decarboxylation in order to align our program with the federal programs.
But it sounds to me like you're extrapolating.
I'm sorry, extrapolating.
Well, you're trying to project a result.
So we are not projecting anything with regard to THC or to Delta 9. We are taking the amount of THCA that's in there. We are using sorry to try to make some motions here. So if you have, say, 100 pounds of THCA, there's maybe this 5-pound component in there that's that dangling acid form. So that A stands for acid. So there's this small piece of a molecule of THCA that's hanging on there. It's a very weak bond. That bond, when it breaks, some mass is going to be lost. So the reason that that formula exists is to remove the potential contribution from that piece of THCA that is not Delta 9 THC. So the reason that that formula exists, it's not to extrapolate, it's actually to benefit the growers and the manufacturers to ensure that it's actually keeping it at the lower possible level rather than taking into account something that's not actually Delta 9.
Let me use an analogy. So you're applying a test to grape juice to tell whether or not it's going to have alcohol after it ferments.
I think that would be fairly similar.
Okay. That's what I mean by extrapolating. Yeah. Okay. All right. We've got several people that want to ask questions. Let me start with, well, I'm sorry, Senator Taylor, I have Representative Balso first. So I'll come to Balso first, then Senator Taylor, and then Senator Lowe, and then Dr. Kumar.
Thank you, Mr. Chairman. Dr. Travis, thank you for your testimony. Is it the department's position that when THCA converts to Delta 9 THC through the decarboxylation process, that the product then has the same or a similar effect on the user as marijuana does?
Yes.
Thank you.
Is there anything more, Representative Balso, or that's it? Okay. Senator Taylor, you're recognized.
Thank you, Mr. Chairman.
Let me interrupt. Somebody's got a phone. Is it outside? Okay. We've got something that sounds like a countdown in Mission Impossible or something. So there may be a recorder about ready to blow up. I'm not sure, but Senator Taylor, you're recognized.
Thank you, Mr. Chairman.
Well, it went away, whatever it was. It just stopped. So,
Well done, Chairman.
okay.
Thank you, Doctor. And as I told you when we met earlier, you did a really good job of explaining where I'm much too stupid for this conversation. So I'm an undertaker by profession, and you're talking about, decarboxylation and symmetry, whatever. The biggest decision we make is would the pallbearers be better on this side of the church or over on that side of the church? That's the biggest decision I make at work. So, but I'm going to try my best to ask a question here. So, on the decarboxylation, is it plant or item specific? In other words, it decarboxylates at different rates, or is it always uniform and they're able to decarboxylate at a uniform rate so you can measure this? Can you help me understand that?
Sure, I can explain that. It is not necessarily going to be a uniform rate. So there are some materials that even if you were to, let's talk about hemp as a kind of a raw commodity. Just like if we're accustomed to seeing a smoking hay bale out in the field, if it gets awfully hot, same thing can happen to hemp. If there's a lot of moisture in there and it's just baled up and put in a barn, there's a good chance that raw farm commodity after it's been tested, before it even leaves the farm, if it's sitting there for too long, enough of that material is going to decarboxylate that it could become potentially a psychoactive material. There's other times where a plant may be immediately trimmed or cut, harvested, manufacturing or further processing happening in a more controlled environment. And it may be possible that that material has a much slower decarboxylation rate over time. So a lot of it relates to the storage conditions of the material. Again, it's possible that exposure to light, to moisture is even possible, could have an impact on the decarboxylation rate. But primarily, it's going to be exposure to heat that's going to adjust the rate of decarboxylation.
Thank you, Mr. Chairman. Then how in the testing are you able to determine that this product, given time and heat, that you're certain it will decarboxylate and be more potent than the 0.3%?
Sure. So there are a lot of studies, and unfortunately I don't have them to cite, that demonstrate the conversion of THCA or the decarboxylation of THCA to delta-9 over time. And there have been many studies that have looked at the rate of decay, if you will. It's not something that happens overnight. At room temperature, it may take weeks, if not months, to get the majority of that decarboxylated. But if you have a situation where a flour-like material may have 30% THCA in there, you're talking about 1% of that material needing to decarboxylate to get you to that 0.3%. So when we're talking about these high THCA level products that can be grown now, or that are grown, and especially in the surrounding states, if that's brought in and is on a grocery store shelf or is in a licensed retail facility, while it's even sitting there on the shelf, you may see that it decarboxylates into something which, even if we were only looking at 0.3% just delta-9, is eventually going to become hot, if you will.
Thank you, Mr. Chairman. So it's not a question of whether or not that plant or that product decarboxylates to the point that it becomes hot. It's just a matter of when it becomes hot.
Correct.
All right. Thank you, Mr. Chairman.
Senator Lowe, you're recognized.
Thank you, Mr. Chairman. I do have a question for Ag, trying to clarify in my own brain here because we did get a bunch of new Scrabble words. But if I know it's uncustomary, but I wonder if Leader Lamberth would be amenable to a friendly question based on something he had mentioned earlier.
Please go ahead.
Leader, do you, and I'm going to be rude because you're directly behind me, so it's hard to turn and see you. When you said that you felt that these rules met the spirit of your legislation, am I correctly in assuming that the intent was to get a best measurement of what a consumer might put in their body at that point of testing as opposed to at harvest? Is that a safe assumption that I'm making, or am I?
Leader Lamberth.
Not entirely. So previously in the hemp market, what Ag had done is they had tested the products are being grown. And so they tested on a dry weight basis on what, how hot, how much, different substances were in the hemp plant when it was being sold. And then when we passed this bill, we added on to that not only at the time that it was being grown, but at the time it was being distributed. So from the manufacturer, if you will, and also have to have it tested at the retailer. Now, what the end user does with it, I mean, there are folks that can mix all types of different alcohols together. They can mix all kinds of different products together. What an individual does with it, we're not regulating in this particular bill. What we're regulating is what a retailer can particularly sell. So, and we were having that conversation up here a while ago. Everything that they're describing here, an end user could go home and try to replicate in some way. But we're just saying when you get it from the retailer, you're going to know exactly what it is, and it's going to be below a certain amount. So we've added on those other two testing requirements so that the goal is you know exactly what you're getting, and it is below that level of where it would ordinarily get someone high. What they do with it after that is up to them.
Thank you. And you don't have to answer this next part, but if you feel I'm incorrect, please correct me. So I'm kind of looking at this longitudinally. You've got harvest, where you have an opportunity to test. You have an opportunity. It's hard to test something at retail. So essentially what Ag has proposed is something similar to being able to guess, reasonable guess of what would happen at retail so the consumer would know reasonably what might be entailed in that product. And then, of course, you would have what would be done at use, which we can't regulate at all because it happens outside our parameters. Am I reading that longitudinally correct?
Leader Lambert.
Only that they're not guessing, they're using actual known science and known, market-based equations to be able to determine exactly what those products are so that, again, the retailer knows exactly what they're selling, the consumer knows exactly what they're buying, and you just have consistency throughout the whole product line.
Thank you. And so for ag, if I might, Mr. Chairman, and that kind of is a great teeing that up for that. Chairman made the analogy of trying to predict the alcohol content of wine, but obviously, if we look at this in the half-life of uranium, that's a more predictable constant. Would you argue that the well, you used the word right there, decarboxylation, thank you. Would you argue that that is more consistently reliable based on the studies to the half-life of predicting the half-life of uranium or to predicting the alcohol content of a fermenting wine?
I would say that it is about in the middle. So just like, for half-life of uranium, you cannot change the half-life of uranium. It is what it is. Whereas for the production of, how much alcohol is going to be in wine, you can adjust that with how much sugar content you have and everything else. But with this, the molecule itself will follow more similarly to half-life of uranium, but when it's inside of those other consumer products, then you're talking and how the products are treated, then it becomes more akin to how much alcohol content is going to be in wine.
Okay, I'm done, but that is absolutely the worst answer. That not from you, but like I was hoping in the middle was not the answer. Like it was one or the other. Thank you, Mr. Chairman.
Thank you. I've got Dr. Kumar, and then I'm going to come back to Senator Lowe, please. Dr. Kumar, you're recognized.
Thank you, Mr. Chairman. Thank you for your answers. Most of the question I had has been covered by Senator Taylor and Senator Lowe really very thoroughly. So all I have is a remark left in the sense that we are aware of aging wine. We were not aware of aging THCA. And as such, can then a consumer purchase the thing and put it in an incubator and plan to get a higher yield?
If the 0.3% post-decarboxylation standard were not there, yes, someone could purchase a 30% THCA, 0.2% Delta 9 product. They may even leave it in their car on a hot day after they purchased it, and by the time they get it home, some of that could have decarboxylated, and it could then be significantly above 0.3%. Yes.
Thank you. This is not the information we should be giving to our constituents. And coming December 25, this is not the Christmas present they're looking for. Thank you.
Dr. Kumar, we share some constituents, and I can assure you they already know. I'm pretty confident of that. So, Senator Taylor, you're recognized.
Thank you, Mr. Chairman. So, not in talking about the half-life of plutonium, because I know nothing about that. I already told you what I do at work. But I understand bread, milk, and eggs. So when I buy a gallon of milk, when they tested the milk at the dairy, it's safe, and they send it to the retailer, and it's got an expiration date on it because they know that it's going to deteriorate or spoil at some point. And if it's on the shelf beyond that point, they take it off. Same with bread and eggs and other food products. Why can this not be the same way where we know it's going to decarboxylate, but at some point, if you haven't sold it past a certain date, you need to take it off the shelf?
So Patricia, I don't know if you want to take some of that. So Patricia was previously the manufactured food coordinator, so I don't know if you would feel more comfortable answering that one.
Sure. My name is Patricia Zapanos Hart, and I am the hemp program director at Tennessee Department of Agriculture. I will say that it's a complex. And I'm a food nerd, so I do have to just start by saying that we are a no date state. So while companies may rotate grocery products based on date or a best buy, it's not required by law. That's more of a quality standard than a food safety standard. I think that I appreciate your question and trying to think of the long game. But because of different environmental factors, heat, keep it in a sunny display window, things like that, I'm not sure that you could pinpoint a time that would be consistent to say, okay, in 2 months, this has to be removed from the shelf because it may be over 0.3%. While we know decarboxylation is an ongoing process and it will always happen, it's eventual. The rate is just subject to a lot of different environmental factors.
Thank you, Mr. Chairman.
I'm going to call on Senator Bowling, and then I'm going to come back to Senator Lowe, but I do want to make one observation. Again, in the interest of being fair to all parties considered, this rule is in response to a bill that we passed last session. Leader Lamberth, you're going to have to remind me the public chapter number. I'm looking for it. You know, you may wish to, members, you may wish to go back and see what is it?
423.
423. You may wish to go back and see how you voted on this, but the issue here really isn't to relitigate the bill. The issue is, do you believe the rules that have been presented fairly represent the intent of the bill that you voted yes or no for, or maybe you abstained? And let me make another observation, and that is that all these rules have to be signed off by the Attorney General as to the legality and constitutionality of it. So the reason why I say that is maybe a little bit gently put some guardrails on what we're doing here, because really the issue here is, do we believe the rule fairly represents the legislation that was passed? And obviously there's been some very serious concerns over, the testing and whether that's capturing the intent of the bill. We've heard from the bill sponsor who's comfortable with that. We've heard from public comment with people who are not. So I do want to kind of put those guardrails on it, because honestly, we could be here till midnight having this conversation, but we need to get focused on the fact that these rules were promulgated in response to a bill that we voted on. So I hope that'll help the questioning moving forward. We need to kind of tighten it up a little bit and get to the heart of the matter as to whether or not we believe the rules fairly represent the bill that was passed. And then we'll vote up, we'll vote down, and go on with our day. I've got Senator Bowling, Senator Lowe, Representative Clemens. So Senator Bowling, you're recognized. Okay, thank you. Senator Lowe, you're recognized.
Thank you, Mr. Chairman. Just in brief, I think when you talk about does the rule meet the intent, I'm kind of forced in a position where I defer to the judgment of the sponsor, who's worked heavily upon this legislation and where he's gone with ag. But the operative word we've been using here is reasonably reliable. And I don't know that the case has been made to me that the current testing standards are reliable. Like there's too much variation. And I'd love to see some of those studies for you to forward over and to see exactly what the variance is with consistency in testing, because I am curious what 24 hours in a hot window at 96 degrees means to THC. I never thought I would be, but I am now. And so even though I'm probably going to default to the judgment of the sponsor here, I think there's a case for continued reliability in testing in this market. And we often hear this being used analogous to alcohol, and it's not, because alcohol has a test that we can use to measure intoxication. We can judge whether someone is inebriated, and that does not exist when it comes to THC levels. We can test for presence, but there's a breakthrough in science that has to take place before we really understand if someone is overused and is incapable. So we often try to make these analogies back and forth, and we know they don't fit perfectly, but I am concerned that this particular testing we're using in the language, the reasonably reliable, and I'm not so certain that reasonably reliable is that particularly clear. There's obviously not consensus in this room. It's probably hard to find consensus here. So just going to encourage you, if you find other methods, and as we move into 25 with legislation to the growers, if you have other insights on how to get reasonably reliable, more reasonably reliable, I think we would be amenable to hearing it.
Thank you. Representative Clement, you're recognized.
Thank you, Mr. Chairman. And my concern goes back to in reliance on some of the testimony we've heard here today, and I keep hearing all these different variables that impact the potency of this or what it's going to score. And look, I mean, we're talking about farmers here who are producing a product, and I know, having grown up on a farm, there's a lot of variables a farmer can't control, and that's one of the frustrating things and one of the challenges of farming. And all of those things you've described here as having an impact on the testing. And so I think the purpose of rules and regulations is to create some sort of stability in a market and predictability among growers, retailers, consumers, and others. And I think we check a lot of those boxes, but when it comes to this testing issue, this seems to me unconstitutionally vague, because if I haven't heard anything here today, I have certainly heard some people of common intelligence guessing at the meaning of this phrase. That may be giving us too much credit up here, but and we heard the testimony earlier. The growers, they don't know what that means. And in reliance on Mr. Little's testimony, that it doesn't necessarily reflect what's in the statute. And so getting back to the chairman's point as to whether or not this rule aligns with the statute, I don't think it does. And I think it puts an undue burden on everybody in the market. And so for that reason, I have real concerns about this. And I appreciate Mr. Little detailing that in response to Senator Crow's question, why and how it doesn't line up. So I think that's a very telling and variable for me in consideration of this rule. So thank you, Mr. Chairman.
Thank you. I want to hold on just a moment, because Senator Bowling, you asked to be last, but I also had already had Leader Lamberth ask to be last to make a motion, but we still have public comment. And so I don't know if you wanted to ask questions or if you want to make a motion. Okay, but we still have some public comment. So if we could, let's go ahead and do our public comment. And we do want to try to limit this to 2 to 3 minutes, and we might be all questioned out at this point in time. I don't know. We'll see how the questions go. But I think first up was Michael Solomon, who had deferred to the permanent rule. Michael, if you would make sure that your microphone is on, we're going to ask you to be at 3 minutes, and please be sure and tell who you're representing and where it's located.
Yes, sir. Michael Solomon, Tennessee guy my whole life. Born in McMinnville, live in Williamson County, and have businesses all over Tennessee. So, you guys are really getting your hands on this from somebody that's been doing this a while. I helped MTSU do $2.5 million with the cannabinoid research with Dr. Elliot Altman back in 2016. We did living mice trials, human tissue trials. Clint was a part of that, who's here. And through that, I also employ about 125 people in the state, pay millions of dollars in tax dollars, and wanted to talk about a few things. I just want to spend my time really connecting what everybody said. One thing I want to say is when Mr. Lamberth wrote this bill, we were all about it. Everybody in the industry was completely all about it, because it talked about, getting all the bad people out of the industry, putting labels on products, making 21 and up. I have an 11-year-old daughter. I don't want to walk into a gas station with pre-rolled joints sitting there. Nobody wants that. We want to be a destination location. Right? When you go to a dispensary, you're not offended by that stuff. You're going to a dispensary, right? And so I agree with that 100%. Where we have this problem is when Mr. Lamberth wrote that, the definition of THC in the state of Tennessee is Delta 9 THC, period. That's the definition of THC by law in the state of Tennessee. And we don't want any products over 0.3 Delta 9 THC. We're just with Mr. Lamberth with that. Then when that bill went to the Department of Ag for rulemaking, the Department of Ag wanted it to align with their growers rule. So they added THCA to the definition of total THC, which Y'all never voted on that. And so when they did that, and I also want to make a point, I'm vertically integrated. So I own grows, I own manufacturing, I own delivery, everything. And when they made that law, when they made that rule and added THCA to the testing of growers, Tennessee went from having 5,000 licensed hemp growers. We were the #1 hemp grower state in America. We outdid Colorado, and we went to where we have 200 to 400 licensed now. It killed 90% of the industry, of the hemp growing industry, adding THCA to the total THC equation. And now they want to match that to retail. There's not going to be anything to govern. This is 85%. Alex was generous when he said 60% of our sales. This is 85% of our sales. There's going to be nothing to regulate. You don't need to hire any inspectors. You don't need to hire, we'll all go out of business, right? And it is a speculation. What you said about fermenting alcohol is exactly right. If I make milk at my farm, and I send it to a Publix, and a Publix doesn't store it right. They keep it in a shelf that might have light on it, like they're saying. If Publix doesn't store it right, well, the health inspector is going to come in and they're going to get fined. Like, you have another permit that you get. Just, I own a restaurant. If I don't store my eggs right, I get fined for that. I get in trouble for that, right? So just because that one thing could happen, we don't need to kill a whole industry. Right? Just because something could decarboxylate on a shelf sitting under a sun, right? We don't need to kill the whole milk industry just because people could leave the milk out and it could get bad, right? So I completely like where your guys' head at. I love the questions that we've been getting. This will kill my company. It will kill this industry. It will match what they did to farming, which was kill 90% of the industry. And that's our concern here. And it's just that one law. We love everything else, Mr. Lambert. The bill he wrote, we love it. We just don't like when it got to rulemaking, they added THCA to the equation.
Thank you, Michael. Questions for our guest? Senator Crow, you're recognized.
Yeah, I was telling Senator Jackson, I don't know if I'm ready to vote or not. I mean, every 5 seconds you change your mind on this stuff. I guess, so from what Leader Lambert said, the status quo is dangerous and evidently, and the action we took was to protect our citizens. If the status quo is not something that's safe, yet to vote for the change that makes us safer hurts our farmers. Does that mean that our farmers currently and the retailers are engaging in activity that's dangerous for our citizens? That's why this is so difficult to deal with. And so I'm just trying to figure out, you think the status quo is not injurious to our citizens, right?
I think, like I said, I'm vertically integrated. I grow, manufacture, and I do retail. And we test all along the cycles of it. I've actually grown a hemp plant, and we literally tested it every week of its life. And we see this going on, and what I think needs to happen, and somebody else said this up, and this is the whole point. THCA is fine. It does not need to be added to the equation. But I do think somebody said this, which is true, is a COA, a certificate of analysis, does need to have an expiration date, right? That would help. If I bought a product, because think about, since everything you guys are saying, right? Just think about being a business owner real quick. I can't go buy bulk product because I'm scared it's going to decarboxylate. I got to buy small quantities at a time and move it throughout my chain within 30 days, within 60 days, because I don't want to risk something sitting on the shelf and decarboxylating. So I already regulate myself like this. And my personal opinion, all we need to do is regulate the industry like that. When I make a product that's going to go on a retail shelf and I get it tested, I would love, by state license test, I would love to say that test is good for 3 months. That test is good for 6 months. If we just had that and THCA was not in the equation, then we could do this. We could easily do this. We could know that something stayed, is staying good for so long. So I love whoever brought up that. I think that is a big thing that would help me as a business owner and help us as an industry.
Well, it sounds like, it sounds like we all want the same thing. We want to be safe for the constituents, to be safe for our constituents. So I don't know. It's
I would just like the bill to be as it stood before it went to rulemaking to the Department of Agriculture, and they added THCA to total THC, which is not in the definition of these states' laws. So.
Thank you. I believe we're going to go to our next public comment, which is Kathy Lennon. Or did you want to present?
No.
Okay, you're with Farm to Med. Okay, so we're going to go to Alex Valley with Gold Spectrum. Okay.
Thank you. All right, good afternoon, esteemed legislators. My name is Alex Valley. I'm a serial entrepreneur with 3 ventures to my name. One of those ventures is Gold Spectrum CBD, one of Tennessee's largest hemp companies, dedicated to producing high-quality hemp-derived products legally. I stand before you today to express my deep concern regarding the regulations set to take effect at the end of the year, which will ban products containing more than 0.3% THCA using the new total THC method. This change threatens to dismantle not only my business, but also the livelihoods of countless others in the hemp industry across our state, some of which we've heard today. When I began working to establish Gold Spectrum, I meticulously adhered to both federal and state guidelines, ensuring our products remain compliant with the legal thresholds of 0.3% Delta-9 THC. The sudden implementation of these new rules feels akin to a rug being pulled from under us, jeopardizing the foundation upon which we built our operations. The impact of this regulation is far-reaching. Our customers who rely on our product for various wellness needs will lose access to safe and legal options. This change would push hemp customers across the state to the readily available underground market and stops the retail tax revenue that has been going to our state. By the way, that's about $16 million so far. Our roughly 200 dedicated employees who have poured their skills and passion into this industry face the uncertainty of unemployment. This also disrupts the hemp-focused supply chain that is built throughout Tennessee. Moreover, the vast economic contributions of businesses like ours, Mike's, everyone else's you've heard today, to the state's economy will be significantly diminished or halted altogether. This change undermines the trust businesses place in regulatory frameworks, as it introduces uncertainty and instability into an industry that has been striving to grow responsibly within the legal parameters set forth. While I understand the necessity of regulation, it is imperative that such measures are implemented within the bounds of the law and with consideration for the industries they affect. The Department of Agriculture's decision to enforce these rules appears to overstep its regulatory scope, imposing restrictions that could decimate an entire sector without due process or proper stakeholder engagement. I urge you to issue a negative recommendation on these impending regulations. This is not merely about compliance, it's about preserving the integrity of businesses that have operated in good faith under existing laws. It's about protecting the jobs of hardworking Tennesseans and ensuring that our state remains a place where entrepreneurship and innovation can thrive without fear of abrupt and detrimental policy shifts. Not supporting this policy change will support the continued growth and stability of the hemp industry in Tennessee, protect local businesses and jobs, and uphold the principles of fair and transparent governments. Thank you for your time and consideration.
Thank you. Do we have any questions? Any questions for our guest? Thank you very much for being here today. I would like, we'll go back to Senator Bowling and Leader Lamberth here, but I do want one bit of clarification. We were looking at the public chapter, and I'm not clear on the comment about THCA being added back to the definition. I want to, since you were the one talking about all the testing, could you address that? Because we're trying to look here at the public chapter and make sense of what it says, or any of the three of you, if you wish to.
Sure, I'm happy to address that, Chairman. Could you just clarify for me what it is that you are asking?
The definition, I think, of total THC, we started out, I think when Michael was giving his testimony, he said that that it was, we were talking about being Delta 9, but then THCA got added back into it. And forgive me, Michael, if I'm not quoting you correctly. I'm doing my best.
So I'm trying to sort out in my head how to best answer this question. So number one, the language that is in this statute is exactly the same as the language that's in the grower statute. So we are interpreting it the exact same way that we would for the growers because it's the exact same language. So it's the same product, same language. The statute for the hemp-derived cannabinoid products has a limit of 0.3% THC on hemp-derived cannabinoids. And the testing method that we are required to use to test all of these hemp-derived cannabinoids is the testing method set forward in the statute, which is in a manner similarly reliable to post-decarboxylation. Now I'm having problems too, and I say this word every day. That testing method affects THCA, and that is why we are talking about it. The department is not limiting THCA per se. It's the testing method that's at issue in the statute. And so when we received the over 19,000 comments from individuals, the department had limited staff to review those comments, but we had all of the expertise necessary to respond to the comments and structure the statute and the rules accordingly. And so we responded to industry as much as we could. The one thing that we included most of what industry asked in our rules. The one thing that we could not change was industry's comment, and we heard them about the limits on THC and the limits on THCA. And the reason we could not make those changes as requested was because that testing method and the limit are set in statute. And all the department has done is in its rules is repeat the language in the statute as prescribed by the legislature. We are doing our best to follow the directives of the legislature.
Thank you. And what I'm seeing, and I don't know that I have the right reference, but I'm seeing TCA 43-27-202, subdivision 2. Well, actually B, where it says it includes, but it's not limited to, and it's listing, Delta 8, Delta 10, et cetera, et cetera, et cetera. And then the last one it lists is THCA. Am I looking in the right place?
THCA is listed in there as a hemp-derived cannabinoid. Yes, that's one of the things that's stated in the statute as a hemp-derived cannabinoid.
Okay. So some of the confusion over the testing, what I'm hearing you say is you did it that way because you had to, because that's actually in TCA. And the reason it's in the bill is you all mirrored what was in the grower. Okay.
Correct.
All right. So let's see who's got questions now. And I'm sorry to interject that, but I just want to make sure that I understood. Senator Bowling, we have, I think you probably want to make a motion, and I know Leader Lamberth wants to make a motion, and I'd actually told him that I would call on him for a motion. So here's what I'm going to do. Hold on just a moment. So what we'll do, I know we may have some competing motions here, and just members, you just vote the way you want to vote, and if a motion fails, we'll take up the next motion. Representative Reedy, you're recognized, please.
Thank you, Mr. Chairman. Question for the Department of Ag, and of course, we've heard numerous times already that we're taking the flower off the table. You agree or disagree with that statement?
Anything that tests as 0.3% or less THC when tested in a manner similarly reliable will be compliant with the regulations.
Okay, thank you.
But let me make sure I understand that. So what does that mean then? I mean, does that mean that people are having to pull things off their shelves, or does that mean that they just, What does that mean?
Since before July of 2023, this was an entirely unregulated industry. So this is first-time regulation. So there are a lot of products that have not been tested because they haven't been subject to testing standards or labeling standards or any of the other safety features in both the statute and the rules. So if there are products on the shelves that are not compliant with the statute that's now in place or the department's rules, then they would not be compliant products to sell in the marketplace.
Okay, thank you. Senator Bowling, you're recognized.
Thank you, Mr. Chairman. The federal 2018 Farm Rule, the bill legalized hemp products. And as we go, hemp is hemp. Marijuana is marijuana. Marijuana is controlled. Hemp is not. It's not a controlled substance. But they can legalize hemp products as long as they contain less than the 0.3% delta-9 THC measured before any processing. That's pre-carboxylation. Tennessee's new rule imposes stricter standards than federal law, creating inconsistencies that burdens the state's hemp industry and make it difficult for producers to comply with both state and federal laws. And that's the simple matter. You're going to do to them what you were doing before any processing. And now it's putting the cart after the horse, or I'm not sure how to say it. But at any rate, right now, that's why I would like a motion to divide the question.
Okay, hold on just a moment. Senator Bowling has a motion to divide the question, and we had a second, but I don't know exactly. You're gonna have to.
I would like 0080-10-02-.05 parentheses 2, parentheses close, parentheses A, parentheses close, parentheses 1, parentheses close, parentheses Roman numeral 6, parentheses closed, parentheses open, Roman numeral 2, parentheses closed. A negative recommendation while giving a positive recommendation to the rest of the rules packet.
Okay, that's not going to be possible, and I'm going to let Council Garrett explain why.
Thank you, Mr. Chairman. Doug Garrett with Legal Services. The guidance we've received from the Secretary of State's office is that we can only bifurcate down to the point number. Any subdivisions below that are taken out, but others are left in, cannot be left in.
So in other words, it has to be much more broad than
What
what.
is included in that?
You have to stop here. You have to stop. You have to end it right there.
So I can go to 0.0080-10-02-.05. That.
Okay. Do you need a moment to look at that and? Just hold on just a moment.
So all of this section highlighted with your motion, we would be removing all of that instead of just this one. It would remove it, but we don't remove all of that, which I'm personally fine.
Little said that if we took that whole section out, it would still stand.
I'm going to recognize Representative Clements to ask a legal question, then I'm going to come back to Senator Bowling. Representative Clements.
Thank you, Mr. Chairman. And this question's probably for Mr. Garrett. If we were to adopt a negative recommendation for this 0.05 subsection, what's the impact of that? Because it's only a negative recommendation. Does that leave it to the discretion of the department to enforce the rule up to a certain date? Does that automatically sunset it after 180 days? What's the legal impact of a negative recommendation for that subsection?
Councilor Garrett, you're recognized. And by the way, that's what we were just discussing at that moment when you asked the question. And I'm not sure that the two of us really agree on the answer, but I'm gonna defer to him. So, and the reason why I say that is we've done it before. Now he's gonna make an interesting statement, but we've done it before. Yeah. So, yeah. Go ahead, Doug. You're recognized.
Doug Garrett again with Legal Services. Since we're dealing with a permanent rule, any negative recommendation that occurs here, the effect of that would not be borne out until the passage of the rule omnibus bill, which occurs generally, as you all know, March, April of each session. So until that point, the rule would continue on as filed. And we're talking about the permanent rule. So that's kind of where we are here relative to bifurcating any portion of a rule or not. One of the questions that's been bandied about is if you bifurcate a portion, that 0.05 or whatever other portion of the rule, does that leave the rule in contravention of what's prescribed by statute, what passed last year in Public Chapter 423? I don't have the answer to that. I'm not the subject matter expert on this, but certainly in the past we've been relying on the department to make those statements and to speak to that issue about the impact bifurcating has on the remainder of the rule. So that's kind of where we are. But long story short, the rule will go on even if it's bifurcated. The rule will go on as filed.
So I always deferred to Doug's legal advice, and of course, my incredible legal argument in response to his comment when we were having this conversation was, "But we've done it before." So I mean, that's where it gets kind of confusing. Is we've done some things before, and trying to sort out the consequence of it. Do you have a follow up on that?
Yes, Mr. Chairman, thank you. So, Mr. Garrett or Chairman, what I'm hearing is it would be up to the department's discretion whether or not to enforce that provision in the meantime until there was final action on the omnibus. Is that a fair statement?
Yes, and go on the record. Yes, please.
Doug Garrett with Legal. Yes, I think that's a fair statement.
And I will say too, keep in mind the whole objective of what we're doing is, do we include something in the rule omnibus bill or do we not? I mean, we're not changing whether or not the rule is in effect. So, Councilor Garrett.
Thank you. This is not to say that legislation could not be brought. I mean, legislation could be brought in the interim to make all sorts of modifications, but that's up to the will of the members of the General Assembly.
Senator Bowling, I'm not sure that we've got a workable motion, and I do know that Leader Lamberth is going. His motion is going to be for a neutral recommendation. I don't know if that influences what you're doing or not, but you're going to have to restate your motion in a way that gets it at a high enough level. And I think our concern is what else gets pulled out of the rule. And we may need to look to the department and say, if all of this gets pulled out, what are we left with? And do you have anything at all that's enforceable? And to what extent is it enforceable? So let's see what the motion is, and then we'll come back to the department. Are you prepared, or do you want me to call on Chairman Crow? He had a question. You're prepared? Let's go ahead then. Let's go ahead.
I'd like to make the motion to divide the question, and by removing 008-10-02-.05.
do we have a,
Negative recommendation.
do you have a page number for that so members can
Six-
find that in their packet?
609.
609. And could you repeat the reference one more time, please?
0080-10-02-.05 for negative, should remove that portion of it.
And that would go all the way to
Negative recommendation on that
page 614.
Mhm.
Okay. And what I want to do is, we had a second on that motion, but it's been restated. Do we still have a second on this motion? We do have a second. We're going to have some discussion on the motion. Leader Lambert, what I'd like to do is turn to the department and ask how they believe this would impact the rule. May I
See, these are
defer to them?
good,
Okay.
this part.
Without objection, I'd like to hear from the department. So are we clear on what her motion does? And if this portion gets pulled out of the rule, what's the impact of that? And how you would intend to proceed with respect to enforcement?
Good afternoon, Mr. Chair. Can you hear me?
We can, yes.
Very good. My name is Jay Miller. I'm General Counsel for the Tennessee Department of Agriculture, and I appreciate the opportunity to address this body. In a nutshell, if 0.05 were pulled out of this rule, these are all of the variances for all of the solvents that are allowed in synthetic materials that the legislature sought to control in the interest of protecting consumer safety. We have nothing to stand on to keep people from putting chemicals that I can't even pronounce into gummies that people can get their hands on. It also invalidates all of the testing standards that will allow third-party labs to take part in this process. So we won't have any way of registering those labs to test the products that the industry is wanting tested. It also takes out all of the remedial actions that industry could have for products that failed. So when we're left with something, if we do have something to test and it fails, we don't have an avenue to give them a second bite at the apple to fix it. Taking out 0.05 is a major blow to these rules and to the goals that this legislature sought to accomplish by passing the bill in the first place.
Okay, thank you. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. I'll be brief. I oppose the motion. I deeply respect the senator for bringing it, but we just can't gut all the safety mechanisms that are put in these rules. The department worked very hard on the bill that we passed to put rules in place that are going to try to help keep people safe. And allowing all these foreign chemicals and everything else and not having multiple testing allows for people to be endangered in this state. And that, again, was a huge part of bringing this bill, is so that we test and actually regulate the materials that are being sold. So I would ask members to vote opposed to this motion, and then I would have a follow-up motion afterwards.
Representative Clemens, you're recognized.
Yeah, thank you, Mr. Chairman. And I didn't want to leapfrog the sponsor of the motion because I know she had a question too, but I just want to raise a point. I mean, we're talking about public safety here. And if you want to threaten public safety, let's shift this entire industry to the black market. And that's what's going to happen. And I understand, and I really value the language of this and the list of those chemicals that we admittedly can't pronounce in some cases. But there is a worst case scenario here, and that is what testimony has told us will happen if we take the flower off the table, so to speak. And we also heard testimony from an attorney that the law covers most of this already, and so the compliance with the law as written would still be in effect even if this 0.05 section is removed, or at least receives a negative recommendation. So that would be my response, Mr. Chairman. I appreciate it.
Thank you. Any other discussion on the motion? Chairman Crow, you're recognized.
Was I correct in the council was telling us either way we go on this, we have a chance to, in the meantime, but prior to the omnibus bill being dealt with, either way we go, we would have the opportunity to pass legislation to fix whatever needs to be fixed. Am I right or not?
Would you like me to answer that question? The answer to your question is when we go into session on January, any member and member of the House, member of the Senate can file a bill. They can be assigned to a committee. If that bill prevails, if it gets 17 votes on the Senate floor, 50 votes on the House, we can completely undo, change, alter whatever we're doing today in time for the rule omnibus bill. Well, wait, it would not be, yeah, it would go into effect in 90 days. So
if we go with the neutral motion, we would have time to think about what we want to do to really take an approach that Senator Bowling is talking about as well. I mean, we would have time to think about it and go from that perspective.
So this whole thing kind of opens up a can of worms, and I'm going to say that we've had this conversation before about separation of powers and what is the legislature's right, what's the administration's right. And, there are some people that believe this whole thing that we're doing right now is on thin constitutional ice anyway. And I acknowledge that. I don't agree with it, but I acknowledge that. So the reality of it is what we're here today outside of our legislative session making a recommendation. But what we do in session, through the committee process on our floor, can take anything we've done today and change it. So so your premise is absolutely correct. The rest are just details. Okay. Rather lengthy details. It's if that clock is right, it's there's no telling how many hours we spent on this. I'm going to go to Leader Lamberth and then any other discussion on Representative Crawford. Can I defer to him first? Representative Crawford, and on the motion, please.
Thank you, Mr. Chairman. My question is with the emergency rules we voted on earlier, and if this passes, they would have to follow those emergency rules for the 90 days before that took place. Is that correct?
The 90 days or the emergency rules expire on December 25th. So the emergency rules that we did as item number 1, they expire on 12/25.
Okay, so their ability to be able to regulate and license and do these type things would run out on the 25th, and then it would go back to the original way it is now?
The permanent rule would pick up on midnight of December 25th.
Thank you, sir.
Okay. All right, Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And my concern is literally that we don't throw the baby out with the bathwater here. I mean, the industry and everyone else that says, look, the vast majority of this they agree with. And now we're talking about gutting an entire section here, which I understand the senator wanted to go all the way down to the granular, but that's not permitted. It'd be one thing if we're just talking about the THCA, which is included in the original bill that I carried, but we're not talking about that. Now we're talking about voting against a regulation that keeps harmful metals and everything else out of these products. I just can't imagine that we would want to send that message to the department and say, look, we don't want you testing. We don't want you regulating this. My ask would be to vote against the motion to separate this out and to just, and again, I'll make a motion on a neutral recommendation. I'd prefer a positive recommendation. I think the department's done an excellent job, but at least the neutral says, look, these rules can go forward. You can license, you can test, but it is a message to everyone, both the industry and the department, that we'll continue to work on this when session hits. And I fully intend on carrying a bill. I'm sure there'll be other people carrying bills as well. And then the statutes that we pass can overrule any of these rules. And we can have that debate on the separate floors as we should, but to not have rules that would regulate this kind of defeats the purpose of the entire statute. That's just my opinion, Mr. Chairman.
All right, I want to make sure that everybody's clear on what happens. So Senator Bowling has a motion to strip this out of the rules. If that motion were to prevail in both chambers, the rule still goes into effect on 12/26, and I'm kind of watching peripherally to make sure I'm not saying something wrong here from legal. But what happens is it generates an amendment to strip it out of the rule omnibus bill in March. So are we all clear on what we're doing? So if we vote for the striking of this, it simply means that each chamber would prepare an amendment pulling this section out of the rule omnibus bill. Now, if it succeeds in one chamber and fails in the other, the chamber that it succeeds will prepare an amendment to pull it out of the rule omnibus bill. The other chamber will not. So consequently, we'll have two separate rule omnibus bills, which will require activity by one of the bodies, either in committee that we fix it or conference committee. And we had that happen last year. So, but I do want to be clear, it does go into effect on 12/26, regardless of what the outcome is. What we're voting on today determines what happens in session, whether we prepare an amendment or not. So, Senator Bowling, you're recognized on the amendment.
Thank you, Mr. Chairman. And this might be a question for the industry, but right now they are operating the way they're operating. And they are testing already for the heavy metals, for the different dangerous things that could be in hemp. They're testing all that at the growing level. So no fault, no foul. You've got a tested product that's tested where the federal law really said it had to be tested at the growing level. The hemp 0.03, 0.3 at the growing level. So that's still in effect. And what this new rule would be doing was going down to that level after the growing and after producing, which was not part of the federal rule. So I think that to deny this in its totality, we might want to come back with some new rules, but it's not going to leave us without the product already having been tested for the chemicals and the dangers and the lead and the poisons and all these things that you can't identify. They're already being tested for at the growing level. Is that correct?
Okay, well, let's get back to the motion. So we have a motion before us. The motion
That's
is
already
to
being
strike
tested.
this particular section from the rule. If the motion prevails, what that means is there will be an amendment prepared by whichever House or Senate approves it, and there'll be a motion to pull it out of the rule omnibus bill. So we have a proper motion, we have a second. And Madam Secretary, if you would, please take the vote in the Senate. And let me make sure everybody, a yes vote means that you want to have it struck. A no vote means you want it to stay in. So just so everybody's voting the way they intend. Go ahead.
Senator Bowling.
Yes.
Votes aye. Senator Crow. Votes no. Senator Jackson. Votes no. Senator Kyle, Senator Lowe. Votes no. Senator Oliver. Votes aye. Senator Rose, Senator Taylor, Chairman Roberts.
No.
Votes no. Mr. Chairman, you have 2 aye, 4 no.
Okay. We'll do this a voice vote in the House if we can. All those in favor of striking it, I'm trying to say bifurcation, striking it, all those in favor say aye.
Aye.
Those opposed say, please say no.
No.
We'll do a roll call, please. Madam Secretary.
Rep Bolso. Votes no. Rep Chisholm. Rep Clemens.
Aye.
Votes aye. Rep Crawford. Votes no. Rep Eldridge. Votes no. Rep Faison. Rep Hakeem. Rep Hemmer. Rep Johnson. Votes aye. Rep Jones.
Aye.
Votes aye. Rep Kiesling. Votes aye. Rep Kumar. Votes no. Rep Lafferty. Votes aye. Rep Littleton. Votes no. Rep Martin. Rep McCallum. Rep Reedy. Votes aye. Rep Rutter.
No.
Votes no. I'm sorry, Leader Lamberth.
No.
Votes no. Mr. Chairman, you have 6 aye, 8 no.
The quick version is the motion failed. Wait. Okay. Madam Secretary, hold on. Everybody hold on. Madam Secretary, would you repeat the votes in the Senate and will you repeat the votes in the House? The tally, please.
In the Senate, 2 aye, 4 nay. In the House, 6 aye, 8 nay.
All right, so we didn't have the prerequisite number of votes in the Senate. That's what the conversation's about. So it failed in the Senate, and of course it failed in the House. So at this point in time, I'll recognize Leader Lamberth for his motion.
Thank you, Mr. Chairman. At this time, I would make a neutral recommendation on the rule.
Do we have a second? We have a second from Representative Bolso. Any discussion on the amendment, please? No. Okay, thank you. Senator Bowling, you're recognized. On your motion or on the neutral? Regardless of what we do, it goes into effect on December 26th. Regardless of any action we take in the committee today, the rule goes into effect on the 26th unless the department were to withdraw the rule or we were to do a stay on the rule. And the department could withdraw the rule and they could reissue the rule if they want to, but they've not given any indication that's what they choose to do. And it's not, we don't get to be the boss of them and tell them to do that. That's the very non-technical constitutional answer. So we could suggest it, but we can't insist it. We could put a stay on it, but that's not the motion in front of us. So, the bottom line is this, if we don't like it, and I know a lot of us have problems with this, I mean, we do. The only way to really, fix this effectively is to do it in January. I mean, it's legislation in January, and I'm sorry if I'm sounding frustrated.
Mr. Chairman,
Yes, ma'am.
so if we fix it at the very first session in January, how many people will have gone out of business, or what would be the negative impact? What would be the negative impact of the black market swooping in to fill a void? Do we know? The rule as written exceeds the federal requirement.
Well, the emergency rule is already in effect. But then, I mean, but pragmatically, you get into the question of enforcement and who can do what when, and so I don't have an answer for you. I'm sorry. Okay, we're on a motion, so we need to keep it relevant to the motion. Okay. Leader Lamberth, we're back on your motion. You have
Yes.
a motion for a neutral recommendation, and I don't see any other comment on the motion, so we have a second. So Madam Secretary, if you would take the vote in the Senate. This is for a neutral recommendation.
Senator Bowling.
No.
Votes no. Senator Crowe. Votes aye. Senator Jackson. Votes aye. Senator Kyle. Senator Lowe. Votes no. Senator Oliver.
No.
Votes no. Senator Rose. Senator Taylor. Chairman Roberts.
Aye.
Votes aye. Mr. Chairman, you have 3 aye, 3 nay.
Okay, let's take a vote in the House. Let's just go ahead and do roll call in the House, please.
Rep. Bolso. Votes aye. Rep. Chisholm. Rep. Clemens. Votes no. Rep. Crawford. Votes aye. Rep. Eldridge. Votes aye. Rep. Faison. Rep. Hakeem. Rep. Hemmer. Rep. Johnson. Votes no. Rep. Jones.
No.
Votes no. Rep. Kiesling. Votes aye. Rep. Kumar. Votes aye. Rep. Lafferty. Votes aye. Rep. Littleton. Votes aye. Rep. Martin. Rep. McCallum. Rep. Reedy. Votes aye. Rep. Rudder. Votes aye. Leader Lambert.
Aye.
Votes aye. Mr. Chairman, you have 10 aye, 3 nay.
Okay, per the House motion, it goes out with a neutral recommendation in the House. And in the Senate, it just is nothing. It's like it didn't happen. And so, we don't have enough votes. Hold on just a moment. So just so everybody understands, a positive recommendation or a neutral recommendation, a positive recommendation, a neutral recommendation, or no recommendation all have the same effect. It's only a negative recommendation that would have any effect. And that only effect would be that it would generate an amendment during session to pull it out of the rural omnibus bill. So, and that's why I'm trying to explain, it's going into effect on December 26th unless the department withdraws the rule. Senator Bowling, you're recognized.
To stay the rule?
Well, you'd have to have a quorum to, yep. Okay, we're going to have to call the chief parliamentarian because we've already had a motion action on the, and well, it failed in the Senate, but it didn't fail in the House.
We've had differences before.
Yeah, but, okay. We're going to take a recess for 10 minutes. We're out of recess. I want to thank everybody for their patience, and I especially want to thank those of you that are on the calendar. I mean, it seemed like such a good idea at the time to go ahead and run both these Department of Agriculture rules at the same time. What was I thinking? I don't know. So some of you just get the extra gold star for having to wait patiently for your rule to be heard, but hopefully the end is in sight. I also want to thank everybody for their patience. I have been on this committee for every single year I've been in the Tennessee General Assembly. And I guess at this point, except for Chairman Crow, I may be the most tenured person in government operations, and I've never seen a conversation go on this long about a rule. And let me just make this observation. As frustrating as maybe today might have been at times, this is what the people of Tennessee have sent us here to do, and that's to make sure that what we do is thoughtful, that we're deliberate, and that we try to hear both sides of an issue, and we try to make good decisions. Sometimes we just agree to disagree, and that's it. But again, just to put it all in context, the discussion that we're having today is on a bill that we voted on not this past session, but actually the year before last, and we're trying to get it right. And so we have some really legitimate disagreement on what some things say or what they mean, and you know, sometimes with this kind of robust discussion, passions can get high, but I hope we never lose sight of the respect that we have for each other, and that that even if we walk out of here feeling like we maybe won or lost, that we still realize that we're trying to do good work for the state of Tennessee and the people of Tennessee. Okay, where we left it was this, and I'm going to explain what might, you know, what the options are here. So when we left, Senator Bowling was wanting to make a motion to put a stay on the rule. And the reason that she's able to do that is because the motion in the Senate did not succeed. It didn't receive the prerequisite 5 votes that it needed. So basically, we're still open in the Senate for business, so to speak. And so she's going to make a motion in a moment, and she'll have to identify, you know, the length of time for the stay. If that receives 5 votes in the Senate, it will succeed. If it doesn't receive 5 votes in the Senate, it will fail. Now, we're not going to take a vote in the House on this stay because this is a Senate action. But the way TCA is actually written, either chamber can put a stay on a rule. So the House has already taken their action. They've got a neutral recommendation. What that means is this rule will be in the House omnibus bill come session. So depending on what happens with Senator Bowling's motion here, we will either have a stay on the rule or we won't. And if we don't have a stay in the rule, it means there was no action in the Senate, and it means that it will be in the rule omnibus bill in March for the Senate as well. So if her stay succeeds, then, you know, we'll have a stay for X number of days. If her stay fails, then everything moves ahead as if nothing happened. Can you believe that? As if nothing happened today. So, so that's where we are. So I already know we're going to try to. I think we all pretty much know where we are. I'm going to recognize Senator Bowling for a motion. She'll get a motion or a second, and this is just the Senate that's doing this. But out of respect for Leader Lamberth and the fact that this was his bill originally, I'm going to recognize him to speak on the motion, and then we'll take the vote up or down in the Senate. But there's no House vote on this motion. This is just a Senate vote. Okay. I would ask the audience if they have any questions, but I don't think we do that. So I'm going to go ahead and recognize Senator Bowling for her motion.
Thank you, Mr. Chairman. And I do make a motion for a 90-day stay, and with the expectation that we'll be able to visit this as soon as session goes back into session, and we'll be able to accomplish what needs to be done legislatively. But that would give us the time to do that. And I think that everyone here is in agreement that a lot of these rules are outstanding and great. The one that does a post-process rather than the pre-process of 0.3% is the point of contention, and we need to make sure that we're doing what's right for Tennessee and for the business people in Tennessee and for the citizens of Tennessee. So my motion is to stay the rule for 90 days.
Okay, we have a second. We have second from Senator Oliver. Okay, let me recognize the Senate first for any discussion on the motion. Do we have any motion or any discussion within the Senate? Okay, I'm going to recognize your leader, Lambert, for some comments.
So, Mr. Chairman, just very briefly, and Senator, deeply respect you, but I would ask that we again, I stated this earlier, not throw the baby out with the bathwater. I mean, this is a good set of rules that AG has put together. It is a good law that we all passed. And I would simply ask that we not stay that, because they have licenses that have been issued. They have fees that have been paid. They have individuals that are very professional. We've heard from some of them today that, quite frankly, will stand out and be able to sell products that are much safer than they ever would have been before. And so to stay that entire rule that requires testing, that requires licensing, that requires everything else over one tiny product that is within this, I just think would be bad policy. And it certainly would destroy the bill itself that we passed 2 years ago. Thank you, Mr. Chairman.
Thank you. And Senator Bowling, I failed to mention this in my comments when I was talking about what if your state succeeds, to the department, I'll say this: you all have you're in a position where you can choose to withdraw your rule, amend it, and resubmit it, and I don't know all the specifics of that, but just be aware that if a stay does take place, that doesn't mean that you all can't continue to do work on the rule if you choose to do that. So, okay, I'm sorry, I meant to mention that before she made her motion. Any other discussion on the motion within the Senate? Seeing none, Madam Secretary, if you would please take the vote.
Senator Bowling.
Aye.
Votes aye. Senator Crow. Votes no. Senator Jackson. Votes no. Senator Kyle. Senator Lowe. Votes no. Senator Oliver. Votes aye. Senator Rose. Senator Taylor. Votes no. Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 2 aye, 5 no.
All right, pending. So the final vote was what? Say it again, please.
3 aye, 4 no.
Okay, so here's what that means. There was no 5 either way. So that means that pending any, in the absence of any other motion, it moves forward without a recommendation. So in the absence of any other motion, I'm getting ready to bang the gavel and we're done. The rule moves out with a neutral recommendation in the House and with no recommendation in the Senate. Item number 3 on the agenda is, all right, thank you all for being here and thank you for your patience. Actually, this is item number 2 on the agenda. I said number 3 because we moved number 9 out of order. So it's Department of Commerce and Insurance, Fire Prevention, Third-Party Inspections, Third-Party Plans and Fees. And I see Mary Beth and I see Mike Bell. So who gets to speak today? You know the drill.
Mr. Chairman, my name's Mike Bell. I'm the Assistant Commissioner of Commerce and Insurance over Fire Prevention. And to my left, I have somebody y'all all know, Mary Beth Gribble, who's the Director of Policy under Fire Prevention. Appreciate y'all having us here today. We have some emergency rules. These are the third-party inspection and plan review emergency rules. These rules address Public Chapter 771 and Tennessee Code annotated 68120 -101K, which allow individuals to utilize Tennessee's registered engineers, architects, and other certified professionals that are registered with Fire Prevention Division to perform third-party plan reviews and third-party inspections in lieu of utilizing a local inspector. In the event of a local jurisdiction fails to act, the person may submit documentation to the division for review. The emergency rules were filed to implement a statutory process passed during the 2024 session and to facilitate the act, which became effective on October 1st. The rules established registration requirements and terms for the revocation of a registration with the division for the use of third-party plans examiners and third-party inspectors in exempt jurisdictions. The rules detail documents required for submittal to the division after a third-party plans examiner or third-party inspector has exhausted the exempt jurisdiction's review process and is requested review by the division. The rules establish an inspection and plans review process. And lastly, the rules state the division fees for review of the third-party plans and third-party inspections. Mr. Chairman, that's the explanation of the rules, and we await any questions.
Members, do we have any questions? Seeing none, do we have any public comment? None. Do we have a motion? We have a motion for a positive recommendation from Representative Balso. Okay, let's look alive here. Do we have a second? We have a second from Representative Littleton. Yeah, amen. It's been a long day. So, there may be people in the audience, Mike, that don't know that you used to chair this committee.
Yeah.
Have you ever seen a rule take so long?
No.
No, that's,
No. We had some long ones, but I don't think 3.5 hours.
I may have the world's record. I'm not sure.
You do.
So,
I think,
okay.
I think
All
so.
right.
I gladly give it to you as well.
And I would gladly give it back if I could. Okay, we have a motion for a positive recommendation. We have a second. Do we have any discussion on the motion? Seeing none, Madam Secretary, if you would, please take the vote in the Senate.
Senator Bowling votes aye. Senator Crow votes aye. Senator Jackson votes aye. Senator Kyle, Senator Lowe votes aye. Senator Oliver, Senator Rose, Senator Taylor votes aye. Chairman Roberts
Aye.
votes aye. Mr. Chairman, you have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor of a positive recommendation, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you for waiting on us today.
Yeah.
I appreciate it.
Thank you,
So-
Mr. Chairman. Thank you, committee members.
All right. Item number 3 is Department of State Safe at Home Program. The Tennessee addressed confidentiality regarding the general program provisions. Thank you all for being here today, and make sure your microphone's on and state your name for the record and give us a brief explanation of the rule.
Good afternoon. Michael Harmon, the General Counsel for the Secretary of State's Office. I'm here with Janet Kleinfelter, the Director of Business and Charitable Organizations and Special Counsel for our office. We first have a set of rules for our Safe at Home program. Our Safe at Home program provides a confidential address to victims of domestic violence, sexual assault, and other specified crimes. Last year, the General Assembly passed Public Chapter 620, which updated our Safe at Home program to make it streamline the process for re-enrollment in the program. You're enrolled for a 4-year term, but unfortunately, some people need the address confidentiality program beyond that 4 years. And it also updated some definitions that made it more accessible to victims of crimes. Stand ready to answer any questions you may have about the rule changes.
Thank you. Any questions? Any public comment? See none, we'll entertain a motion. We have a motion for a positive recommendation from Representative Reedy. We have a second from Representative Lafferty. Any discussion on the motion? See none, Madam Secretary, please take the vote in the Senate.
Senator Bowling votes aye. Senator Crow votes aye. Senator Jackson votes aye. Senator Kyle, Senator Lowe votes aye. Senator Oliver, Senator Rose, Senator Taylor votes aye. Chairman Roberts
Aye.
votes aye. Mr. Chairman, you have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you all for being here today, and thank you for being patient. Yes, go ahead, please.
Got another rule.
Oh, you're next too. Yeah, your number 4 regarding the charitable organizations. Please go right ahead.
Michael Harmon, General Counsel for the Tennessee Secretary of State's Office. We have proposed rules before you that update our charitable solicitations rules to reflect changes that were required by the passage of Public Chapter 533 and Public Chapter 615. Public Chapter 615 reduced the regulatory requirements on folks that file with our office. Public Chapter 533 was generally a cleanup bill, and we have these rules to come back in line with those 2 chapters. The cleanup bill, for example, if you're requesting an extension, it clarified that the good cause standard is to be applied. I'm happy to answer any questions about the specific changes, all of which are only designed to address the requirements from 533 and 615.
Thank you. Any questions on the rule? We've got a motion for a positive recommendation from Senator Lowe. We have a second from Representative Lafferty. Okay. Any discussion on the motion? Do we have any public comment? Seeing none. Madam Secretary, if you would, please take the vote in the Senate.
Senator Bowling votes aye. Senator Crow votes aye. Senator Jackson votes aye. Senator Kyle, Senator Lowe votes aye. Senator Oliver, Senator Rose, Senator Taylor votes aye. Chairman Roberts
Aye.
votes aye. Mr. Chairman, you have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor of a positive recommendation, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you
Mr.
all.
Chairman.
Okay, we're on number 6 now on your agenda. This is Department of Commerce and Insurance. And They've got some repeal of several rules just following the bill that we passed that requires departments go through and remove their outdated rules that they have. So thank you all for being here today. If you would give us your name and title, and I think probably we'll just let you proceed with explaining what you're doing. And members, just be aware of the fact that there's going to be a real kind of a real breadth of what they cover here, and just be alert if you have any questions on these particular sections of code. Go right ahead.
Good afternoon, committee. My name is Candace Dawkins. I'm the Legislative Director of the Department of Commerce and Insurance. I'm joined by Michael Driver, who is our General Counsel. And I apologize in advance. We have 58 rules that we are requested to repeal, and I will, as briefly as possible, go through them for the record. And so all of these were done as a part of our comprehensive retrospective rule review. Rule 0780-02-04-.07 on certificates of compliance for park trailers and recreational vehicles, which provides requirements for manufacturers to obtain certification decals from the Department of Commerce and Insurance for park trailers and recreational vehicles, is repealed because the manufactured housing section no longer has jurisdiction over those vehicles. So the rule is no longer needed. Rule 0780-02-05-.02, adoption by reference of standards, which sets standards applicable to manufactured homes, is repealed because it is duplicative of statutory requirements in TCA 68-126-403. Rule 0780-02-05-.04, permits and inspectors, which contains information regarding applying for, paying for, and replacing a manufactured home permit and permit decals, is repealed because it is duplicative in statute 68-126-406. Rule 0780-02-08-.08 effect, which lists certain things that the chapter does not do specific to factory manufactured homes, is repealed because it is not necessary since the chapter doesn't do any of those things. Rule 0780-05-02-.24, proprietary security organization, unarmed security guard officer registration card, regarding unarmed security guard registration cards issued to employees of proprietary security organizations, is repealed because Dallas's law, or Public Chapter 1121 of 2022, made the procedures contained in this rule unnecessary, as it removed the ability for unarmed security guards to obtain PSO cards. Rule 0780-05-09-.07, change of ownership, which requires the department to be given notice at least 30 days before the closing of a proposed sale of a cemetery by the buyer, is repealed because TCA 46-1-107 already requires notice to be provided by the seller. Rule 0780-05-09-.26, paper size, which requires documents submitted to the burial services section to be on certain size paper, is repealed because that restriction is unnecessary. The chapter 0780-05-13, which contains 16 rules regarding the regulation of locksmiths, is repealed because Public Chapter 572 of 2021 removed the regulation of locksmiths by the department. Rule 0780-05-18-.17, severability, contains a severability clause for the rules for the debt management services program, and that's repealed because there is no purpose for a severability clause in rule. Chapter 0780-01-25, which contains 6 rules setting guidelines to be followed by companies offering life insurance policies to college students under a premium financing agreement, is repealed because the authorizing statute, TCA 56-6127, was repealed in 1988. Chapter 0780-01-30, which contains 4 rules related to signatures of accrediting actuaries on annual insurer statements filed with the department, is repealed because Rule 0780-01-37 outlines the requirements for filing annual statements, and that rule is redundant. Chapter 0780-01-32, which contains 8 rules related to the right of domestic insurance companies to enter into certain transactions and exchange traded call options, and to establish procedures for such transactions, is repealed because the National Association of Insurance Commissioners, or NAIC, their accounting practices and procedures manual covers these issues and prescribes the accounting treatment, so these rules are no longer necessary. Chapter 0780-01-73, which contains 6 rules for the TennCare Oversight Program Division regarding claims processes for TennCare participating managed care organizations, is repealed because the authorizing statute, TCA 715191, and the standardized billing and claims processing requirements established in this chapter were superseded by the national billing standards established by HIPAA. Lastly, Chapter 0780-01-48, which contains 10 rules regarding reporting requirements under the Tennessee Healthcare Liability Reporting Act, is repealed because that act was repealed in 2021 by Public Chapter 537. Which one? This last one? Yeah. I missaid a rule. So the last one was Chapter 0780-01-84.
You know, everybody on this committee was sitting here thinking, she missed one. All right, members, do we have any questions? Senator Taylor, you're recognized.
Thank you, Mr. Chairman. Thank y'all for going over those rules, and thank you for bringing rules to us to consider repealing. You know, at the last meeting, I don't remember if it was your department or another department, I specifically asked the question if this effort through the comprehensive retroactive rule review, if they only brought obsolete rules, or if the departments were looking for rules that would streamline the regulation for businesses. And Chairman Reagan at the time, he said, nope, it was to bring obsolete rules to us. Is that your understanding as well?
Yes.
Thank you, Mr. Chairman, if I may. I'm glad for you to bring obsolete rules to us, but I guess I'm really more interested in having the departments review rules and bring rules that need to be consolidated or streamlined or rewritten that will make it easier for businesses to start and operate rather than just bringing obsolete rules to us. Is that something that's within the purview of your authority now, or is that something that the legislature needs to act on?
Thank you, Senator. Michael Driver, General Counsel with the department. During the review, we not only identified rules to be repealed, which is the package before you today, but we also identified potential amendments that I think are in line with what you're asking. And so those were not part of this process, which was filed as a proposed rule and is going through that process and has specific restrictions on it. And so we do have a number of amendments identified that would have to go through the traditional rulemaking hearing process as well.
Thank you, Mr. Chairman. Well, I'm glad to hear that. And I hope other departments will do the same, because if we're just going to repeal obsolete rules, I mean, that's kind of like peeing in a wet bathing suit. You get a nice warm feeling, but nobody notices. And so I would hope that y'all would bring those rules that you can consolidate and streamline back to us. So thank you, Mr. Chairman.
I was trying to figure out what that had to do with being an undertaker, because you usually manage to work that in, but motion for a positive recommendation and a second. Any discussion on the motion? Any public comment? Seeing none. We have been here for way too long today. Madam Secretary, if you would please take the vote in the Senate.
Senator Bowling. Votes aye. Senator Crowe. Votes aye. Senator Jackson. Votes aye. Senator Kyle. Senator Lowe. Votes aye. Senator Oliver. Senator Rose. Senator Taylor. Votes aye. Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor of a positive recommendation, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you all for being here today, and thank you for your work on that. All right, Department of TennCare, you're next. Welcome. Thank you for your patience. If you would, please make sure your names are on the record and please give us a presentation of your rule.
Good afternoon, Mr. Chairman and members of the committee. I'm Amanda Petrie, Associate Counsel with TennCare. On my left is Dan Kilpatrick, Senior Associate Counsel with TennCare and also our Rules Attorney. And on my right is Dr. Renee Williams-Clark, Chief Pharmacy Officer for TennCare. TennCare has one item for your consideration today, item number 7 on your agenda, starting on page 154 of your packet. This concerns amendments to permanent rules involving TennCare's pharmacy program. TennCare is amending various provisions of Rule Chapter 1200-13-13, TennCare Medicaid, and TennCare Rule Chapter 1200-13-14, TennCare Standard. Specifically, we revised definitions and added new definitions related to TennCare's pharmacy lock-in program, which is our program designed to address and reduce abuse and overutilization of pharmacy benefits by TennCare members. We updated provisions outlining our pharmacy services so that they better align with current practice, and we updated provisions related to our prescriber attestation list and clarified how members may access that information. We also removed opioid prescription limitations for members with sickle cell disease and members who are severe burn victims so that our rules align with nationally recognized best practice standards. We offer this change with the full support of stakeholders who regularly work with us to help address the needs of this vulnerable population. We modernized provisions related to our pharmacy lock-in program to clarify provisions that will allow us to continue to reduce the risk of misuse of controlled substances. The rule amendment does not establish this program. This program has been in existence since 2004 pursuant to Tennessee Code Annotated 715146. We did conduct a rulemaking hearing for these rules on March 7th, 2024, and received public comments from 4 interested parties. We appreciate those comments we received, and we responded to the interested parties in writing to explain how the rule amendment was intended to be administered. Based on the feedback and the explanations we provided, we did not make any additional changes to these rules. The net result of these rule amendments is that we are clarifying provisions that provide oversight, including mechanisms that allow for early intervention to target or reduce member abuse. These changes promote safer and better outcomes for our members and help us maintain the integrity of our program. We are happy to answer any questions.
Thank you for that explanation. Do we have any questions for our guest? Do we have any public comment? We'll entertain a motion. Do we have a motion? We have a motion for a positive recommendation from Representative Reedy. We have a second from Leader Lamberth. Any discussion on the motion? Seeing none, Madam Secretary, would you please take the vote in the Senate?
Senator Bowling. Votes aye, Senator Crowe. Votes aye, Senator Jackson. Votes aye, Senator Kyle, Senator Lowe. Votes aye, Senator Oliver, Senator Rose, Senator Taylor. Votes aye, Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor, please say aye.
Aye.
Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you all for being here today. Appreciate it. All right. Next on the agenda is TDEC. Welcome. If you would take a seat and give us an explanation of the rule. Be sure to say your name for the record.
Thank you, Mr. Chairman and members of the committee. My name is Allie Williamson. I'm the Legislative Director for the Department of Environment and Conservation, and with me today is Michelle Oakes from our Division of Air Pollution Control. TDEC's Division of Air Pollution Control, through this rule, is proposing to incorporate by reference all new source performance standards except emission guidelines. Incorporation by reference is used by air programs in the U.S. given the significant difficulties of keeping the rule up to date with a word-for-word approach. TDEC is seeking regulatory clarity by incorporating these rules by reference for our various industry categories in the state and to maintain consistency with federal regulations. There are no new fees or additional regulations imposed by incorporating these rules by reference, and with that, we're happy to take any questions.
Thank you. Do we have any questions? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. I guess in the public comment, you got public comment from the EPA, and in their public comment, they said that there appears to be inconsistency and differences between the language in the federally approved state implementation plan and what is being revised in the draft rules. And it says that you did not change based on this comment. I mean, if the federal government is saying that our rules are appear to be inconsistent with what they've laid out, isn't that a serious problem?
Thank you. So what the EPA is referring to is within the state implementation plan, and TDEC is working with EPA. Our air pollution control is in contact with them, and we're working to revise that. But based off of these rules, a lot of these changes that we're asking to make today will bring that up to standards. So this is addressing a lot of what EPA's concerns are.
I guess I'm confused because it says in response to this comment, the division did not make any changes to the rules.
Yes, thank you, Representative Johnson. Yes, we are working on that as a kind of parallel effort along with the rulemaking with the incorporation by reference. So with our parallel effort, we've had to update our SIP by identifying historical rulemakings, and that is going to be kind of moving along in parallel with the rulemaking. So once this rulemaking becomes effective, we're working on updating the SIP, and it should all go in parallel, if that makes sense.
I guess what doesn't make sense to me is that we're going ahead and doing it before that is done and before we see it.
So here's the issue with the updating the SIP. So the issue was these historical rulemakings were never transmitted to the EPA, but they did go through public comment participation in historical rulemaking documents. We have documentation of that. So these historical rulemakings date back to kind of the early 2000s, and early 2000s, and we're filling in the gaps to update those SIPs by transmitting those to the EPA as the rule becomes effective. I hope that makes sense.
It really doesn't, but thank you.
Any other question for our guest? Do we have any public comment? Seeing none, we'll entertain a motion. We have a motion for a positive recommendation from Representative Littleton. We have a second from Representative Reedy. Any discussion on the motion? Seeing none, Madam Secretary, please take the vote in the Senate.
Senator Bowling? Votes no. Aye, sorry. Senator Crow? Votes aye. Senator Jackson? Votes aye. Senator Collins? Senator Lowe? Votes aye. Senator Oliver? Senator Rose? Senator Taylor? Votes aye. Chairman Roberts?
Aye.
Votes aye, Mr. Chairman. You have 6 ayes.
Thank you. We will do a voice vote in the House. All those in favor of a positive recommendation, please say aye.
Aye.
Those opposed, please say no. The ayes have it. The
No.
rule moves out.
No.
We've got some no's. Okay. So Jones, Johnson, and Clemens, if you would record as no, please. Rule moves out with a positive recommendation. Thank you all for being here today. All right. We're now in Department of Mental Health. This is item number 10, Substance Abuse Services, Controlled Substances. Thank you all for being here. Thank you for your patience today. If you would introduce yourselves and give us an explanation of the rule.
Good afternoon, Chairman and members. Excuse me. My name is Angela Jackson. I'm the Assistant Director of Legislation and Rules for the Department of Mental Health and Substance Abuse Services. To my left, I have Dr. Wes Gimmon, who is the Chief Pharmacist and State Opioid Treatment Authority for the department. The rules before you today are the department's Controlled Substances Schedules rules. As you recall, TCA 39-17-403 requires the department to revise and republish these annually. In doing so, we consider the actions the DEA has taken with the federal controlled substances schedules and input from state agencies such as Department of Health and TBI. Since we undertake this activity annually, these rules are developed as of a point in time, and controlled substances that are added, deleted, or modified at the federal level after the filing date of these rules are considered when developing future annual updates. Also, as we revise these annually, I know a number of you are familiar with these rules. These rules are drafted in collaboration with the Tennessee Department of Health, the Board of Pharmacy, and in consultation with TBI. The department held a public hearing on June 26 and received no oral or written comments. These rules will go into effect on December 18th. And with that, we ask for a positive recommendation and are ready to answer any questions you may have.
Thank you. Do we have any questions for our guest? Do we have any public comment? See none, we will entertain a motion. We have a motion for a positive recommendation from Senator Lowe. We have a second from Leader Lamberth. Any discussion on the motion? See none, Madam Secretary, if you would, please take the vote in the Senate.
Senator Bowling. Votes aye. Senator Crowe. Votes aye. Senator Jackson. Votes aye. Senator Kyle. Senator Lowe. Votes aye. Senator Oliver. Senator Rose. Senator Taylor. Votes aye. Chairman Roberts.
Aye.
Votes aye, Mr. Chairman. You have 6 ayes.
Thank you. We'll do a voice vote in the House. All those in favor of a positive recommendation, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you all
Chairman
for
and
being
committee
here today.
members.
Okay. All right. Next up is the State Board of Education. And they actually have all of the rest of the agenda today. So we have saved the best for last. You're recognized.
Didn't get all dressed up for nothing, Mr. Chairman.
That's right.
I'm Nathan James with the State Board of Education. I'll ask each of my colleagues to introduce themselves.
Rachel Supay, General Counsel with the State Board of Education.
Jack Powers with the Department of Education.
Robin Ye with the Department of Education.
Okay, our first one, Education Savings Account Rule, TCA 49.6.2601 establishes the Education Savings Account Program, and 49.6.2610 authorizes the State Board of Education to promulgate rules to effectuate that program. Let's see, 49.6.2601 and our Education Savings Account Chapter 05200116 outlines the student eligibility requirements and participation requirements for the ESA program. These proposed changes will align the rule with requirements of non-public schools and provide additional clarity in select program areas. The reference to criminal background checks is revised to cross-reference and align to the existing approval requirements for categories 1, 2, and 3 non-public schools. The current criminal background check requirement in the rule for participating ESA school place additional requirements on schools that are both duplicative and confusing for interested schools and current partners. To clarify requirements for schools interested in or currently participating in the ESA program, this item adds additional options towards financial verification. Currently, the rule states that a school may submit a surety bond to demonstrate financial viability. This item adds the option for a participating school to also submit a CPA letter or federal tax return form to verify the financial viability. The item also removes references to expense reports throughout the rules to align with how participating families currently access funds. Each account holder must submit a pre-approval form reviewed by the department for all expenses. When that form is approved, the account holder can then submit the request for funds disbursement for tuition, fees, other allowable expenses. The school then submits an invoice to the department for review and for the disbursement of funds. Additionally, any purchases made in the TN Choice Portals Marketplace has been pre-approved by the department, having followed rigorous internal procedures regarding receipts and invoices. Therefore, any reference to expense reports or expense report processes is no longer applicable to the current program's implementation. Lastly, the item removes the requirement that the Department of Education provide notice of an appeal decision via first-class U.S. Postal Service mail. The department will continue to provide notice of appeal decisions electronically. The State Board of Education held a public rulemaking hearing on these sections on 25 July 2024, and we had no public comments submitted either in person or electronically, which we did to make sure anyone statewide could participate.
Thank you for that explanation. Do we have questions? Representative Clemens, you're first, and then I'll have Representative Johnson, then Representative Jones. You're recognized, Representative Clemens.
Thank you, Mr. Chairman. My question is with regard to the elimination of the criminal background check language. You had mentioned that that was confusing. And can you elaborate on how it is confusing and why we're eliminating that provision altogether?
I'm happy to to clarify that. This is just updating the rule to align to the laws and rules that are already in place regarding criminal background check requirements for non-public schools. So rather than having those requirements listed both in this rule and in our non-public school approval rule, for efficiency and alignment, this rule will just refer to the criminal background check requirements in the non-public rule.
And are the criminal background check rules different for non-public schools and public schools? And if so, how and why?
There are some slight variations. It depends on what category of non-public school we're talking about. But there are some differences that are set out in statute, outside of the board's purview or jurisdiction, really, I should say. One of the differences is that in public schools, there is a requirement that every 5 years, those background checks be reviewed or updated. And that's more of a best practice in the non-public school setting. But I'm also, going to ask Nathan to chime in if I forgot anything, as well as my department colleagues.
Are y'all chiming in?
I didn't know if they had anything else to add, but they're telling me to turn my microphone off.
I think only one works at a time. It's good to be surrounded by smart people. I think you've got it covered. If we missed anything that you all can think of.
Jack Powers at the Department of Education. The only thing I would mention is just from a timing perspective too. This is important context. When these rules were written originally on the Education Savings Account program, it was pretty much immediately after that original law passed. And since then, the rules on non-public schools writ large, which included language on criminal background checks, were updated after that fact. So that is another reason why you're seeing just some of that, the changes made to align directly with what the new updated rules on non-public schools say. That explains a couple of the other kind of smaller clerical changes in this rule as well. Just that timing piece on when we did the ESA rules versus when the rules on non-public schools were then updated.
Thank you. Yeah, and I certainly understand, non-public schools can do what they want for the most part in a lot of ways, right up until they start receiving state tax dollars and public school students who are taking funds away from public schools. So then they become, an extension of the state almost. And so we do have a say at that point. And I don't understand why we would allow more lax criminal background checks at that point. It seems like we would want them to be just as stringent as the public schools once we start giving them state tax dollars. My next question is with regard to the surety bond issue. The surety bond was required before, but now we're making it a either or with the CPA statement or the school's most recent federal tax return. My constituents have a lot of concerns about the fiscal integrity of these private schools that want to receive vouchers and whether they're going to be fly-by-night schools and what have you. So the fiscal integrity and stability of those schools is a serious issue if we're going to be sending Tennessee taxpayer dollars to those schools. So why are we providing the state less protections here? It seems to me a surety bond and either of the other two would be more appropriate. Why are we not requiring that?
Thank you for the question, Representative Clemens. So a couple things I want to note here. One, just as a reminder, any of the non-public schools we're talking about related to this program have to be category 1, 2, or 3 non-public schools. And we just referred to the rules that govern those. There are a lot of different requirements for those schools to ensure that they're maintaining things like their credibility and whatnot. One of the other comments I just want to make here related to this rule and the ESA program is unless the law dictates that there should be a difference, one of the main goals with this rule is to not place any additional requirement on a non-public school that the ESA law doesn't require. My understanding of this change, and I do have program staff here who I'm sure can speak more detail to it, is that it's not a matter of one being more rigorous than another. In the spirit of trying not to add any additional requirements on these schools that the law didn't dictate, this option to let them take the CPA route would be potentially not as financially burdensome. Not to say that it's less rigorous than the surety bond piece. That was simply the option in our intent was to give them another equally rigorous way to demonstrate that they met the financial requirements that didn't have that same cost potentially to that school.
Well, I certainly understand your intent there, but that doesn't protect the interest or the fiscal interest of Tennessee taxpayers. If we're going to start sending, and we are sending state taxpayer dollars to these non-public schools, and we're only requiring them to provide us with their most recent federal tax return to assure us that our investment isn't going to get flushed down the toilet by a fly-by-night private school, that seems pretty irresponsible on behalf of the state of Tennessee, whether the statute allows it or not. It seems to me once we start giving them our money, the hard-earned taxpayer dollars through these voucher programs, that we would want to, add some responsibility to them for accepting those. If they want to participate, if they want to benefit from our tax dollars, we have the right to tell them, you've got to prove to us that you're fiscally sound and that you're not going to disappear in a year or a half a year. And the same goes for the criminal background checks. Boo-hoo if we require them to make stronger requirements for a criminal background check. We're talking about the safety of our students. So I don't understand why we're bending over backwards here once we start giving them our taxpayer dollars, why we're going out of our way to make it less expensive for them or less onerous for them to protect the safety of our students. Thank you, Mr. Chairman.
Representative Johnson, you're recognized.
Thank you. Yes, I too am concerned about the criminal background checks. They used to do them every 5 years. Now we're going to one time and not doing them again. My other concern is there no requirement that these background checks are on hand. So if someone comes up to check on something, you can't prove that there was a background check if they are not kept on hand for viewing in the school. Where is the accountability for having done those background checks and not just saying that they had if they don't have to keep them on the property?
I'm certainly going to have the department's programmatic staff speak to that, and we're looking through to.
I'm also just checking to see where it is in the statute where there's a reference
Sorry, I didn't
to
open
no
mine up.
requirement that it be kept on the property. I just want to make sure I'm clear where that is. Normally these kinds of documentations are stored as part of an employee's records. I'm not aware of any exemption in this case regarding the personnel files.
Keith Miner, Assistant General Counsel for TDOE. Just speaking to the criminal background check issues, so the 5-year requirement that seemed to be modeled off of 495413, so that is the public statute for criminal background checks. That actually currently now we have switched over to RATBAC, so public schools actually are going to no longer be doing 5-year checks once they're enrolled in RATBAC. It's a continuous monitoring service. So that's kind of the idea behind that. I think the switch over for the non-public side, the non-public rule, the current non-public rule for background checks allows for a criminal record check that can either be fingerprint or social security number based. Some of the reasons behind that are some of the types of things that can come up in a background check might be more comprehensive with a social security number versus just a pure TBI, FBI background check, which is only going to result in criminal history. So social security numbers can, non-public schools, or a lot of them are going that route as well, just because that will come up issues with, bring up issues with any type of fraud or credit issues that might give non-public schools some concern. So speaking to that, what was the other?
Yeah. So, all right. So you were saying that, I'm sorry, was addressing the first issue. I got sidetracked here. But the first issue was being less not doing the 5 years. And that was your explanation for that. What about the explanation for maintaining the records?
The current non-public rule, as I'm reading it right now, does not have anything that requires the records be kept. It just says prior to employment, all non-public employees shall have a background check if they're going to have proximity to children. So, but whether or not that would be kept on the premises, the rule does not currently speak to that.
Well, what the current rule that you are deleting, says right here, shall maintain documentation that all persons working on school grounds when students are present and or providing services to students have undergone a fingerprint-based criminal history records check forwarded by the processing pursuant. It says right here that it'll be kept on the property.
I believe that actually was taken from the public schools statute, so 495413. So as my colleague mentioned, when this original rule was put into place, it was modeled off of that statute. But since that time, the non-public rule for any background checks was put into place for categories 1, 2, and 3. So I think the intent was to align it so that schools would actually be consistent with what they were doing across categories 1, 2, and 3. So just whether or not they were a part of the ESA program.
Okay, I understand that, but the problem is with that intent, we made it incredibly more lax, and there's no proof that this was done. And I think that's a serious problem. Thank you.
Thank you. Representative Jones, you're recognized.
My concerns were around the same premise about this new rule removing the requirement for record keeping, and how it also remove the requirement that background checks happen every 5 years. And so I just think it's weird that we live in a state where we don't trust teachers to pick books in their classroom, but we want to have private schools be able to have people without background checks and adequate criminal background checks on people who will be with children. I just don't understand the logic behind this.
Mr. Chairman and members, where is that language that you're saying that goes away?
Thank you for the question. I think the misunderstanding is there's a reference that's struck in one section, but it's still in, it didn't remove it. It just removed a reference that was duplicative, is my understanding. So it's still there, and we're not diminishing at all. Am I misunderstanding?
No,
But I
Mr.
think
Chairman,
just-
you're not. And when any of the members of this committee suggest that, of course, I'm thinking, oh, I got to find this thing, because I know y'all do your homework very well on that. So we've been kind of scrambling to try to find this thing, and I think it's just a matter of its a duplicative reference that was changed. But obviously, that kind of scared me a little bit.
Well, let me defer to legal for a moment, but our understanding in our office is it was just a duplicative reference that was removed, and I'm going to defer to Council Garrett to weigh in if he wishes. Okay, he will follow up in a moment, but I think that's our understanding. So let's see if we've got any other questions for the committee while they're looking. Okay. And let me go ahead and ask if we have any public comment on this. I don't believe we do. Okay, let's just sit tight for a moment. Well, let me ask a question for the state board here. Here was my understanding that it was struck in this rule, but it is present in other rules or it's referenced in other places. If you know where that reference is, that will answer the question.
We're pulling it up.
Nathan, let me, so we're looking for the reference and does it apply? Are you guys having any success here?
So in order to qualify as a category 1, 2, or 3 school, they have to, on an annual basis, prove that they're doing these background checks. The specific question of whether that's stored on that location or if it's able to be stored at a different office or something is what's kind of what I know they're all shuffling around to find. The process is in place that requires each of those schools to prove that they are doing all of those criminal background checks. And that's something the department checks every single year for all of those schools. So now that doesn't answer specifically, can it be, at a central repository or on the school grounds itself? So if you'd like, Mr. Chairman, we'd be happy to have it rolled till December or however you want to handle it.
Well, yeah, let me ask you to do it this way if you don't mind the suggestion. Why don't you just stay it for 10 days? And here's why. The effective date will be after our next meeting. Right now, the effective date is before our next meeting. So if you all can, instead of rolling it, asking to roll it, just say I don't know how we word that, but you can just ask for the rule to be stayed for 10 days. File the state. Okay, you can file a stay with the Secretary of State for 10 days, and that'll put the effective date after our next meeting, and then we can just hear it on our next
Come
meeting.
back and chat a bit. Okay.
If we roll it ourselves, it'll go into effect before our next meeting. So, I mean, we need their commitment that they stay it, or else we need to have a motion to stay it ourselves.
All right. I'll make my commitment to you.
Okay.
We'll stay it for 10 days.
10 days, and then we'll roll it to our next meeting.
Okay.
Okay. All right, and send a copy. Yeah, send a copy of state request. Okay.
And
Thank
I'll
you.
also say, Chairman and members, actually, we very much appreciate everybody putting eyeballs and brains on these things. They're, certainly the process works and makes it all better. So we appreciate it.
Well, thank you, and thank you to the members for being alert to these things. Okay, we're going to roll that item to our next meeting, and that will put us then pending the stay filed by the State Board of Education with Secretary of State's office. And again, you'll get that paperwork to us. So let's move on to the next item on our agenda, which is item number 12, employment standards for teachers.
Yes, sir.
All right, go right ahead.
Nathan James, State Board of Education. This is page 841 of your rule packet. 491302 requires the board to set the qualifications, requirements, and standards of and provide the licenses and certificates of all public school teachers, principals, assistant principals, supervisors, and directors of schools. 495108 directs the board to promulgate rules and regulations governing the issuance of licenses for supervisors and principals and public school teachers. The State Board of Education Standards Rule 05200206 defines requirements for certain school and district level positions that educators may hold without holding a specific endorsement. This item proposes revisions to section .01 to clarify that employment standards outline the requirements for certain school and district LEA level positions that educators may hold without holding a specific endorsement. The item also amends section .02 to extend flexibility for individuals to teach year one CTE courses. Currently, these year one CTE courses are only taught in the 9th grade. However, this employment standard would expand flexibility for individuals to teach courses offered to students in 6th through 9th grade by allowing teachers holding a valid Tennessee teacher license with an endorsement through at least grade 8 to teach year one CTE courses after successful completion of a department-approved CTE training process. Lastly, this item also creates an employment standard to align with TCA 4966006, which allows an educator holding an active teacher license to teach a course with an end-of-course examination if the educator demonstrates sufficient content knowledge in the course material by taking and passing at the educator's expense a standardized or criterion reference test for the content area. This employment standard would allow any educator holding an active educator license to teach a course with an end-of-course examination if the educator obtains a qualifying score on the applicable assessment as found in the professional assessments for teachers for Tennessee Educators Policy 5.105, aligned to the active endorsements for the course found in the department's course code management system. The creation of an employment standard provides an avenue to digital credentials for the educator that will assist in annual monitoring and compliance. Certainly gets down to the CTE courses being able to be offered at least that first level, offered a little bit earlier, and also provides the flexibility so that more folks can be authorized to teach those at those earlier points in time. We did hold a public rulemaking hearing on 25 July. We had no public comments there or at either of the board meetings.
Thank you. Leader Lamberth, you're recognized.
Motion for positive recommendation.
Motion for positive recommendation. We have a second from Representative Littleton. Any discussion on the motion? Any public comment? We do not have a quorum in the House, so we're just going to do in the Senate, I'm sorry. So we're going to do a voice vote in the House. All right. All those in favor, please say aye.
Aye.
Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation in the House. It moves out with no action in the Senate. And just to restate what we said earlier today, no action in one particular chamber means it's in the rule omnibus bill. Okay. All right. Next item on our agenda is State Board of Education, item number 13, related to district and school operations.
Nathan James with State Board. District and school operations. 491302 states the State Board shall set policies for the review, approval, and disapproval and classification of all public schools, evaluating student progress, achievement, governing all academic standards and courses of study in the public schools. 491302 requires the board to adopt rules and regulations. Let's see. So State Board Rule 0520-102.17 state enrollment and attendance guidelines outlines requirements for school attendance in Tennessee. Revisions of this rule move requirements for excused absences and for counting students as present from State Board Attendance Policy 4.100 out of policy and into rule in accordance with the statutory requirements regarding those matters. In addition to moving existing language regarding excused absences and situations where students can be counted as present out of the policy, the following revisions have been made. You all were kind enough to pass Public Chapter 549, which allows our State Board student member to actually miss school to come to a State Board meeting, and for that we are immensely grateful. That's reflected here in this rule. Also clarifying that students cannot be counted as present for post-secondary school visits that occur during that TCAP testing window. That's where our high school students can go and visit those four-year institutions and TCATs, et cetera, but don't do it during the TCAP testing window, please. That's what that one says. It also clarifies that students who receive an excused absence or who were counted as present shall be allowed the opportunity to do all their makeup work, and that it remains under the discretion of the LEA whether or not students with unexcused absences will be allowed the opportunity to make up missed assignments. allowing schools to post the LEA's attendance policy on the local Board of Education's website rather than at each school as it was before, and allowing copies of school handbooks to be provided to teachers, administrative staff, parents, guardians, et cetera, electronically instead of in writing. Or in addition to writing, however it was requested, and adding additional language from the law regarding the requirements for LEA attendance policies, clarifying that LEAs who authorize charter schools must ensure that those charter schools have an adopted attendance policy. We did hold a public rulemaking hearing. We had no comments submitted.
Thank you. Any question for our guest? Do we have any public comment? Do we have a motion? We have a motion for a positive recommendation from Representative Balso. We have second from Representative Reedy. Any discussion on the motion? Seeing none, all those in favor, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation in the House. Next item, please. Career and Technical Education, State Board of Education.
State Board of Education, I'm Nathan James, Career and Technical Education 05200107.04. Again, 491302 grants the State Board the power to oversee the instructional programs of the public schools. TCA 4911-101 designates the Department of Education as responsible for administering career and technical education programs in the state. Public Chapter 543 this year increased the maximum number of work-based learning credits a student may earn each school year. Previously, the law placed a maximum of 3 work-based learning credits per school year, and at least 1 credit must be earned through related classroom experience, which must include a minimum of 2 periods per week of classroom instruction. The law also previously specified that a minimum of 10 hours per week of supervised work experience is required for 1 additional credit, and a minimum of 20 hours per week is required for 2. This item presents revisions to the rule to align with the law that you all passed this year to increase the maximum from 3 to 6, and that requires the minimum number of hours of classroom time per week, or that is to say of supervised work experience, my apologies, per week, from 10 down to 5 in accordance with the statute. We did hold a rulemaking hearing, no public comments.
Thank you. Any question for our guests? Any public comment? We'll entertain a motion from the House. We have a motion for a positive recommendation from Representative Reedy, a second from Representative Balso. Any discussion on the motion? Seeing none, we'll do a voice vote. All those in favor, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation in the House. Next item on the agenda, item number 15, related to Occupational Educator Scholarship, State Board of Education. You're recognized.
Thank you, Mr. Chairman. I'm Nathan James with the State Board of Education. Occupational Educator Scholarship Program. So Chapter 204 of the Public Acts of 2019 established an Occupational Educator Scholarship Program to be administered by the Department of Education. 4911-102 gives the State Board of Education rulemaking authority for the administration and management of that scholarship program. The State Board of Education Occupational Educator Scholarship Program rule outlines those requirements.
Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. We have reviewed the rules, and I appreciate you reading them to us. And in many instances, it might be necessary, but I would make a positive recommendation this time.
We have a motion for a positive recommendation. We have a second from Representative Balso. Any discussion on the motion? Any public comment? Seeing none of either, we'll do a voice vote in the House. All those in favor, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Last item on the agenda is District and School Operations, State Board of Education. You're recognized. We'll see if you can beat Leader Lamberth. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. We reviewed the rules that are being presented at this juncture, and I would make a positive recommendation.
We have a motion for a positive recommendation. We have a second from Representative Reedy. Any discussion on the motion? Any public comment? Seeing neither, we'll do a voice vote in the House. All those in favor, please say aye. Those opposed, please say no. The ayes have it. The rule moves out with a positive recommendation. Thank you all for being here today without objection. We are adjourned.
Meet December 11th.